Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, couch potatoes. Happy afternoon. We are getting ready to hear closing arguments in the case of Nevada versus Devyn Michaels, and I am ready for it. I'm curious to see what both sides, how they're going to close this case out. We'll see. They both had, in my opinion, good openings. So let's see how their closing arguments go. I do have a poll going on in the chat, and it is, what do you think the jury's verdict will be? Guilty? Not guilty? Will it be a hung jury? Honestly, I have no idea. I have no idea how this is going to go at all. Many of us are pretty skeptical because there's a lot of holes in this story. So I guess we'll see. Will they reach a verdict today? I don't know. They should have a couple of hours, though. Let's see. It'd be one their time. So if they did 2 hours in closing arguments, which is fair, it's a fair amount of time, an average amount of time, that would take them to 3. They would have a little break. Well, they would just go deliberate, I suppose. And then they would have at least another 3 hours. So we'll see. Will they come back with a verdict today? I don't know. I have a feeling no, but we'll be on verdict watch anyway. So speaking of, make sure that you have your notifications turned on and find them on the home page. There's a little bell thing. You're going to click all notifications. So that way you get notified when and if the verdict drops. Well, it will drop at some point, just a matter of when. You'll know when we go live. Hello, Angie. Hello. She asked, did the defense do anything? Well, they had 2 witnesses they put on. The first was a data guy whose purpose was really being like, so the investigators only downloaded about 3% of all of the data available and didn't take data from many other areas, such as, the Xbox, the Nintendo Switch, different messaging platforms, particularly Discord. They brought up Discord a lot, as there was like a picture, or he was on Discord or something like that at 2 something in the morning. But I was in and out of that testimony because my mom was in town and stuff. So I missed part of the beginning, but that was basically what he was there for, was what I took away from that. And then their other witness was a medical examiner, forensic pathologist, if you will, whose purpose, I guess, was to reiterate to the jury that the medical examiners didn't really do a super great job. And we already knew that they didn't because of the whole tattoo thing. But the medical examiner proceeded to say that, to label the manner and cause of death as homicide for both, where it should be undetermined. Okay. So a lot of people sometimes are like, okay, but like they dismembered the body. So obviously, but that's the thing, is scientifically, they can't say why he died. Sure, we can assume it was murder, but there are many, many cases where people have dismembered bodies, but they actually didn't murder that person. Now, does that make sense? No, but it happens more than you think. That's why some people just get abuse of a corpse charges, because obviously that's not going to happen if, your body's in pieces. That's definitely not natural. But as I was explaining to earlier in our other stream, somebody could OD, they could die of natural causes. It could be an accident. And people have, in fact, dismembered people who have died that way for numerous reasons, right? Especially before there was these laws where, like, it was okay to, if you're with somebody who's ODing and you're doing drugs, that you can, the Good Samaritan law, you can still call it in and you won't get in trouble. But there's been numerous cases like that. And so basically he was saying they don't know that he was murdered. But they know it's not from decapitation because that was done post-mortem. But that it's just not appropriate, I guess, to label it as a homicide, something like that, because they don't have the head. So that was basically the roundup of the defense's witnesses, and then they rested. The judge read jury instructions. They broke for lunch at their normal time. They're going to come back with closing arguments, and then it's going to the jury. So we will see. Oh, you're welcome, Auntie Candy. Hope you're having a good day. Did the Emmy see the tattoos? Right? I mean, yikes. What was the other case that we watched? The Emmy. Was it the Jeffrey Spence one? Where we were just like, that guy was also a cop and a coroner? Or it was one of those where we were just like, ugh, that's not great. That's not great. You did not do a very good job. Actually, it's funny, as earlier this morning, Bro Llama was like, didn't you have a trial where the lawyer said something crazy? And I was like, oh, well, yes, there's been numerous of those. But in the Jeffrey Spence case, when the defense attorney was like, her words are trash. I love that so much. Her words are trash. If I ever get one of those soundboards, I'm going to find that and use that for whenever somebody's on the stand and be like, her words are trash. It was the best. Oh, hi, Holly Mac. Hi, babes. Hope you're doing well and staying warm up there in Canada, because it's been a cold couple of days. Well, the last couple of days have been warm, but oh boy, last week was cold. But hope you're doing well. Oh, Court's back. I hear movement and noise. So let's see how that goes. There we go. Okay. Don't forget to hit the like button, you guys, because it is a new stream. It lets people know that we're live and that they should come hang out with us. Oh, let me boost this
up. We are back on the record at C-377239, State of Nevada versus Devyn Michaels. Name the record reflect on Ms. Michaels is present with her attorney, Deputy District Attorneys on behalf of the state, and both parties stipulate to the presence of our jury.
Yes, Your Honor.
All right. Ladies and gentlemen, we have now reached the portion of trial where closing arguments will be given. Since the state has the burden to prove, the state will get to begin and close the closing argument.
Okay.
State, are you prepared to give your closing argument?
Yes, Your Honor.
All right, whenever you're ready.
Look at that. Well, that's
The
wild.
truth is the truth.
Oh.
It shouldn't change. And the truth is, the walls were closing in on Devyn Michaels and the fantasy that she had put together. And what was her response when her children were taken away? Johnathan had custody, and this was in danger. She did the unfathomable. She murdered Johnathan Willette. The crime charged in this case is murder with use of a deadly weapon. You heard from the judge. She did read that to you folks prior to our break. So what it is willful, unlawful, felonious, and with malice aforethought, the defendant killed Johnathan Willette, a human being, with use of a deadly weapon, be it a wooden stick and or an unknown object, by striking the said Johnathan Willette with the said wooden stick and or other unknown object, and or through other unknown means. The said killing having been 1, willful, deliberate, and premeditated, and or 2nd, committed during the perpetration or attempted perpetration of a robbery. Let's start with the easy one, the deadly weapon. You heard from the defendant that she hit Johnathan Willette with a stick, and he died. So this is clearly showing that that stick that she described to you is a deadly weapon because it resulted in the death of Johnathan Willette.
A stick?
Now I want to point out something very important that's in your instructions, and it's not something to gloss over. The state is not required to have recovered the deadly weapon used in the crime in this case. So keep that in the back of your mind that we are not required to do that. However, we have the confession from the defendant that that is what she used. So that being said, you'll have your verdict form when you go back to deliberate. So I think it's helpful to sort of walk through that. So based on knowing that there was a deadly weapon used beyond a reasonable doubt, we're able then to eliminate guilty of first degree without, use of a deadly weapon, and also guilty of second degree murder, and guilty of voluntary manslaughter. So all that we are left are those charges with use of a deadly weapon. Let's talk about murder. Your instructions tell you that murder is the unlawful killing of a human being with malice of forethought. Whether express or implied, the unlawful killing may be effected by any of the various means by which death may be occasioned. So let's talk about malice of forethought. What does that mean? That is the intentional doing of a wrongful act. So I don't think anyone is going to get up here and say that this was not a brutal first-degree murder. Knowing that, defendant's actions were not voluntary manslaughter. Voluntary manslaughter is the unlawful killing of a human being without malice of forethought, without deliberation or premeditation. It is a killing upon a sudden quarrel or heat of passion caused by a provocation sufficient to make the passion irresistible. That is not what we have in this case. The defendant said in her statement to the police, told the police, that she was giving Johnathan a back massage while he was laying face down on his bed.
Then why even put it on the list of things they can find?
She got up off the bed, made the conscious decision to then walk over to that fireplace that we all saw, grab what she described as a candlestick, an object, right? Walks over, makes a conscious decision to then walk over, goes to the bed, and while Johnathan is still face down, with his head facing away from her, as she told us, she took that stick and bashed the victim in the head. He had no clue that this was coming. Conscious decisions every step of the way. His body goes limp. This is not voluntary manslaughter. The instruction also tells you if there should appear to have been sufficient time for a cool head to prevail and the voice of reason to be heard, the killing shall be attributed to deliberate revenge and determined by you to be murder. The defendant did mention that the victim, Johnathan Willette, had rubbed on her leg. And then she kind of just shooed it off. It was like, okay. And then after that, he seemed happy, right? His face was turned away, thought he was getting more of a massage. But instead, the defendant made those conscious decisions that I just went over and bashed him in the head. This is not voluntary manslaughter. So that being said, when you go back to deliberate, you'll have this form again. We've already crossed off the ones that don't apply, so let's cross off the other one. Voluntary manslaughter with use of deadly weapon. Because no one's going to get up here with reasonableness and say that this was voluntary manslaughter. So then what are we left with? First degree murder. You were instructed that murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. What are those three elements? Willfulness, deliberation, and premeditation. And I do have a graphic photo here, so I just want to warn everyone, including in the gallery, that there will be a graphic photo. This is first degree murder. What is willfulness? Willfulness is the intent to kill. There needs to be no appreciable space of time between formation of the intent to kill and the act of killing. What is deliberation? Deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of those actions. This is very important, and I am going to spend some time on this. A deliberate determination may be arrived at in a short period of time. The best way to illustrate this is the stoplight example. So all of us drive to work, we're on our way to work, and there's a stoplight. Sometimes that stoplight turns yellow. And when it's yellow, you're making some conscious decisions at that point, right? Either you're taking the decision to press on the brakes, but during that you're deciding, well, is someone going to rear end me, right? If I just stop on my brakes, right? Is my coffee that I just bought from Starbucks going to fly all over the car, and I'm not going to have coffee at work if I slam on my brakes? Is my purse going to fly off the seat, and I'm already running late for work, so how am I going to have time to put all the items back in my purse so I can walk into work?
I literally have never ever thought about that.
If I press on the brakes, I'm going to then potentially be late for work. And I've already been written up a couple of times, so this may be the time of fire. All of this is going on in your head when you're faced with that yellow light. You're also thinking, well, I obviously can't press on my brakes, right? So I'm gonna have to go through this light. But what are you thinking about when you're going, making the decision to run that yellow light that's about to turn red? You're hoping there's no top, right? You're hoping that a motorcycle doesn't come out from nowhere and you hurt someone. There's no bicyclist that's just somehow hoping that you're gonna stop at the red light because they see that it's yellow. All of these are conscious decisions that you're weighing, and that is all deliberation in a short period of time. We do it every day. Again, it need not be for a day, an hour, or even a minute, this premeditation, this decision making. It may be as instantaneous as successive thoughts of the mind. The stoplight example. No matter how rapidly the act follows the premeditation, it is premeditated. That is what happened in this case, when the defendant made each conscious decision ending Johnathan Willette's life. We also have another theory of first-degree murder. That's called felony murder. There are certain kinds of murder which carry with them conclusive evidence of malice aforethought. Therefore, a killing which is committed in the perpetration or attempted perpetration of a robbery is deemed to be murder of the first degree. So what is a robbery? You are instructed that robbery is the unlawful taking of personal property from the person of another, or in his presence against his will, by means of force or violence or fear of injury, immediate or future to his person or property, or the person or person or property of a member of his family. Such force or fear must be used to 1, obtain or retain possession of the property, 2, to prevent or overcome resistance to the taking of the property, or 3, to facilitate escape with the property. We heard a lot of evidence over the past 2 weeks, which is why I'm slowly going through this today. We have evidence that the defendant took multiple items of Johnathan's belongings. Social security card, a wallet, his only set of car keys. Why did she want those things? How was she going to enroll the girls at school without having Johnathan's documentation? This all goes into her motive. The defendant obtained Johnathan's property by means of force or violence, i.e., she killed him, and took his wallet, his only set of keys, and his social security card. This is another easy one. That being said, you'll have your verdict form. And between both theories of murder, we are confident that you'll be able to check that first box and at this point eliminate the second-degree murder. But that being said, any way you look at this case, this is first-degree murder. And this is important to note, because when you go back there, you're doing an important thing. But what is also important is that while a guilty verdict must be unanimous, you need not be unanimous on the means or the theory of first-degree murder in arriving at your verdict. What do all those words mean? That means when you go back there and you're carefully weighing the evidence in this case, if 6 of you decide that the state has proven beyond a reasonable doubt the felony murder theory, and 6 of you decide that it's the premeditated deliberate, that doesn't matter. The verdict would be guilty of first-degree murder. You need not be unanimous on the theory of first-degree murder. So there's been a lot of talk over the past 2 weeks about Devyn, and we're not shying away from this. You saw him testify on the witness stand. There is overwhelming evidence beyond what he told you that Devyn did not murder his father. Let's go through that. We'll start with Devyn's testimony under oath. He tells you that he saw his father, Johnathan Willette, at that Porcupine Rim address, the house that he and Devyn shared, briefly on August 6th. You'll recall that he saw his dad in the garage and just went right back inside. They never had a discussion. And he was home at the Porcupine Rim address on August 6th. He told you that he was helping the girls, his sisters, Devyn's daughters, with homework. The defendant, Devyn, tells him that she's going to help John move some things. He goes on about his night. He stays at the house, he watches a movie with the girls, he puts them to sleep. This is what he's telling us. He goes to sleep around 10 p.m. He woke up, he recalls, around 2 a.m. to see Devyn getting in bed, which they shared at that time, and he just went back to sleep.
Which was impossible.
He woke up at 6 a.m. the next morning on August 7th. He gets dressed, he goes to work.
2 hours later.
Even if you don't want to take his word for it, which we believe you should, we also have other evidence to corroborate what Devyn told you. This is a text message that Devyn sent to the defendant, Devyn Michaels, where he texted her, "See you when you get back. I'm going to sleep. Girls are in the living room," corroborating that he put the girls to sleep and he was going to sleep as well. This was on August 6th.
You said nothing about the girls being asleep.
At
Ma'am.
10:36 p.m. We also have video surveillance to corroborate this. No video surveillance shows Devyn's vehicles in Taladura's neighborhood. Taladura being the murder house neighborhood. No vehicles belonging to Devyn are seen. And we spent a lot of time going through that video surveillance on that lengthier day of trial, showing you that there is no indication that Devyn's vehicles are in that neighborhood on the night of the murder. There's no video surveillance showing Devyn's vehicles entering or exiting Porcupine Rim neighborhood, the neighborhood he lives in with Devyn. Remember that fixed camera? There was no indication that his vehicles left that evening, or entered, for that matter. Devyn's vehicle was in the same position overnight. You recall there was sort of that catty corner home that had that footage showing the daytime and the nighttime, and the van, Devyn's van, remaining in the same position, to a T. There's also no video surveillance showing Devyn jumping a back wall to get in another vehicle. There is no evidence of that. What we do have is Devyn leaving in his work van at 7:31 a.m. on August 7th, because that's what happened. We also have the CDR mapping, which also rules Devyn out, beyond his word. If you recall, there was that Detective Good testified pretty in depth. He had color-coded the different phones so that you could see with ease which phones were popping up at which times. You recall Devyn's was green. We see green popping up at that Porcupine Rim Street, which is his home, throughout the night, and more importantly, during the time period of the murder, which we'll talk about later, because we are able to narrow that down.
What is that?
At no point do we see Devyn at the murder house the night of the murder, and even more importantly, during the murder. Again, I explained this, I just want to show it. This is that footage of the nighttime. We see, if you recall, up in that top right-hand corner, we see the victim's truck, Johnathan Willette's truck. We also see right next to it, Devyn's work van. This is the night of August 6th. This is the next morning of August 7th. There's that same work van, Devyn's work van, in the same position. Nighttime, daytime, nighttime, daytime. Never changing. Physics also ruled Devyn out. A lot of discussion about how he jumped the back wall, he took the road that's one house over that, not the road, but the little dirt path, right, to get all the way across town. 7.5 hours? No. That's not common sense. I also think it's important to highlight Devyn and the defendant's relationship, Devyn's relationship. Devyn is a master manipulator, and that is shown through the evidence. This is a woman in her late 30s that decided to begin a sexual relationship with her 19-year-old stepson, who had just lost his virginity. I'm not going to get up here and say that the 19-year-old teenage boy, this wasn't his dream to be with Devyn Michaels, who was an older, more sexually experienced woman. But what I am going to say is that the defendant is the one running the show here. This was her fantasy, and he went along with it. For a while, though. Because remember, he tried to move away to California on multiple occasions, and somehow she was able to spin her web and bring him back. The most glaring portion being when she uses a supposed pregnancy against Devyn to bring him back to Las Vegas. When she threatened him, I will have this baby and tell everyone whose baby it is if you don't move back to Las Vegas. So what does young Devyn do? He moves back to Las Vegas. He doesn't want a kid at his young age and even complicate his relationship with his family that doesn't know about their relationship or their sexual engagements. There's also messages that show that Devyn was in charge of this relationship. He tried to get out multiple times. So now that we've talked about this could not be Devyn, let's talk about who's on trial today. Devyn Michaels, the defendant, and how there is overwhelming evidence that she committed first-degree murder. I'm going to go over a roadmap of all the different evidence that you heard in the past 2 weeks and sum it up as much as I can. We'll start with Yoko and Yoshida's testimony.
Very interesting.
Devyn's inconsistent statements, so her own words. The scene, the DNA, the burlap, which we heard about today again, CDR mapping, video surveillance, the phone contents, and we'll also talk about the custody case and those witnesses we heard yesterday. I think it's very important to start with the timeline because, as Mr. Giordani said, this one's a wild ride and we have to buckle up. So let me start with the timeline here. The timeline starts August 6th of 2023. Devyn, John, the girls, they're all shopping for the girls' first day of school. At 8 p.m., Devyn arrives at the murder house in her vehicle, and Yoko confirms this. At 8:42 p.m., Devyn, the defendant, and John drive to Devyn's home. At 9:40 p.m., Devyn and John drive back toward the murder home. 10:04 p.m., Devyn and John drive from, or they get to Chevron. They're there for a few minutes, as we saw. And then return back to the Paladura neighborhood at 10:12 p.m. And that's even confirmed by Yoko saying that she saw Devyn and John, and that's when John began to prepare a meal for himself. At 11 p.m., a person places something in the Nissan Armada, Devyn's Nissan Armada, moves the Armada in front of the murder house. And what's notable about that, and I think it's important to highlight, is it went from being in front of the camera to being out of the camera, but more importantly, closer to the house, right in front of the driveway, and nose to nose with Johnathan's truck, which we see was in the same position the next day based on the surveillance, as well as the testimony from the officers in this case. We then turn to August 7th, 2023. At 1 a.m., Yoko runs into Devyn for about 15 minutes or so. At 2:04 a.m., Devyn leaves the murder home in her Nissan Armada. At 2:39, she's at that CVS drive-thru that we saw the surveillance video for. And then at 8:40 a.m., there is that 911 call from Johnathan's mother when she discovers her son dead. We can then safely say on this timeline that the murder that Devyn committed occurred between 10:12 p.m. and 2:04 a.m. So knowing this time frame, we're able to look at the corroborating evidence. Let's start with Yoshida's testimony. The day before the murder on August 6th, he sees Devyn at the murder house. And more importantly, he also saw her vehicle at Paladura. We heard from Yoko. Again, around 8 p.m., Devyn arrives at Paladura in her Nissan Armada. Devyn and John then leave in John's truck. Around 10 p.m., Devyn and John return to Paladura. Yoko sees them. After seeing them, she goes upstairs. At 1 a.m., she goes back downstairs. She runs into Devyn, and what did she describe to you? Devyn looks surprised. Why? Importantly, Yoko also says that the light was on in John's room. Of course, you also heard that the way the bed was situated, you would have to walk into the room, down, and go around to actually see the bed. But regardless, she sees that the light is on in the room. Devyn tells her that John started drinking and he went to bed. Yoko told you that she didn't hear anything from John's room. The light was on. Didn't really think anything of it. And that she and Devyn talked and washed dishes for about 15 minutes. Because that's when Devyn told her that Johnathan the next morning was going to meet her with the girls, and they were going to go ahead and go enroll the girls at school and take them to school. She confirmed to you that there were only 4 people at the home. Yoko, Yoshida, Devyn, and the victim, Johnathan. At 1:15, she goes upstairs. She goes to sleep after having that conversation with Devyn. Around 2 a.m., she wakes to the dogs barking in the backyard, and if you'll remember, that was abnormal. The dogs, when John was asleep, or at night in general, were not in the backyard. So why were they in the backyard barking? She also heard a thud. She then goes back to sleep. At 8 a.m., she goes downstairs, sees John's truck is outside, which is a little weird because Devyn had told her that the plan was for him to already be gone by that time in the morning to go enroll the girls. So her antennas were up a little bit. She calls him, calls John, he doesn't pick up, prepares her coffee, goes back upstairs. She calls him again, no answer. So now her senses are heightened even more. So she goes back downstairs. She looks around John's room, couldn't see him. because again, the bed is sort of around that corner, as you saw in the photos. She then goes upstairs again. After going upstairs, again, feeling even more heightened concern, she goes back downstairs. And it's at this point she goes deeper into John's lower room, a makeshift bedroom. She sees that the doggy door is down and the dogs are still outside, abnormal. She saw inside the garage door was half open, the one leading into the garage, abnormal. The big garage door was open as well, as you all saw in the photos. It had an opening there, abnormal. So then she investigates more. She goes to his bed, and she sees John wrapped in a blanket. She opens the blanket, and she saw feet. She then goes around to the other side of the bed and sees the amount of blood that's on the other side. Goes upstairs, tells Yoshida, they call 911. Devyn also made several inconsistent statements. The truth is the truth, it should change. What were those inconsistent statements? The first one, Johnathan's engagement ring. If you recall in interview 1, Devyn tells the officers, we threw his engagement ring in the trash last night. Okay. Interview 2, threw away John's engagement ring. We kind of made a joke of it, 2 points, threw it in the trash type thing. So it should be in the trash, right? We saw pictures of the trash, of multiple trashes in the Paladura address. Not just one, but multiple. 1, 2, 3, 4, 5. None of them containing a ring that were searched by officers. Ladies and gentlemen, there was no ring that was thrown in the trash. Inconsistency 2, her marriage to Devyn. We learned from interview number 2 that this was a marriage of convenience, not intimacy, which we know is not true based on other evidence in the case. Interview number 3, her marriage to Devyn is just on paper, rings aren't significant, me and Dev haven't been intimate in years.
I mean, that's exactly what Devyn said, so.
Inconsistency 3, the gun safe. In interview number 1, Devyn tells officers, we took the guns last night, but we didn't bring ammunition because there's no safe at my home for them. Ladies and gentlemen, we saw pictures of a safe. There was a gun safe in the home. There's a close-up of it there. And there's guns and ammunition. Gun safe in the home. No safe. Inconsistency 4, Johnathan's wallet. In interview number 2, she tells officers, John lost his wallet yesterday, he leaves stuff around a lot, minimizing. Then we have interview number 3, which is after the search warrant of Porcupine Rim, where they start to confront her with the fact that there's Johnathan's items in there, more specifically his wallet. She tells them, at first, nothing of John's is in my house. John's wallet wasn't at his house, so do you know where it is? No, sir. I have all of his old driver's licenses. The license you found is an old one. We know that's not true. I tucked the wallet away in bags. I knew, but how would she know that the wallet was wrapped in bags in her underwear drawer? She wasn't confronted with that. Nothing of John's in my house. There was. His only set of car keys. His current driver's license. His wallet. And what was found inside her purse? Johnathan Willette's social security card. Why would she have those things? But nothing of John's at her house. Again, the license you found is an old one. And if we look here close up, it expired November 7th of 2025. The murder happened August 7th of 2023. This was his active driver's license. His old one. I tucked his wallet away in bags. Remember, ladies and gentlemen, this wasn't one bag. This was 8 bags, and you heard in the interview the detective line off that were tied over and over and over and over again. Not just one bag. What was she trying to hide? Also, how would she know? Inconsistency 5. Where was John? In interview 1, she tells officers that John was in the garage, awake, smoking when she left. He was smoking when Yoko came down. But remember, Yoko said Devyn told her John was sleeping off his alcohol. So which one is true? She says she said goodbye to him, pushed out a box under the garage, went out the front door. Then the next interview, last thing she did with John was pop his back. He went to smoke. She talked to Yoko. She finished loading. He told her what to take, and that was it. All inconsistent. And not the same story. Inconsistency 6. John's bloody phone found at Devyn's home. There's a lot of discussion about this during the trial because it's important. And it shows that Devyn committed the murder. And why? First of all, she told us in interview number 3, he told me he cut his hand. Okay? He said he was moving a table and one of the parts fell and took a chunk of his hand. She offers this to police. I didn't see it, but I do know he mentioned bleeding on his hand. Very descriptive. Then interview number 3. He must have been smoking and set his phone down. Again, no notifications are found on John's phone, as if someone manipulated it. Because as we know, John was called and texted multiple times, especially when people were trying to find him. Why would he have no notifications on his home screen? That's because the phone wasn't left by John. You know that his blood was on the phone. And we know that it arrived after the murder based on those CVRs. Based on that raw data, we know when John's phone made it to Devyn's residence. And that's when she took it there because, as you know, it traveled with her after she committed the murder back to her home. This is also an important one. She tells detectives that it was dark in the room and she couldn't see when she committed the murder. In interview 4, we finally get her confession. She hit him. And that's when we get the details. But she tells us that she couldn't really see what she grabbed off the fireplace because it was dark, but she could see him breathing. She tells the detectives, because they're a little confused by that statement, because she can't describe the object in her very hand, but she's able to see Johnathan breathing. She tells him, well, your eyes can adjust. And remember, Yoko said the light was on in John's room when she came downstairs. It wasn't off. It's also important to note that he was wearing boxers. He had his boxer briefs on, she tells the police. And we know that's not true. The boxers were found at the foot, next to the side of the bed, as shown right here. She also can't really account for the time after seeing Yoko at 1 a.m. And this one's really important. In interview number 4, she initially tells detectives, well, I wasn't there for an hour after Yoko came down. That's not true. But then she's confronted that no, there is evidence that you were in fact there until 2:04 in the morning. So detectives trying to solve this case for the family is asking, what were you doing? What were you doing in that time frame? She remembers every detail before. She remembers every detail after you heard the interview. But she doesn't remember this time frame. Why? Because she did it. She was decapitating Johnathan. I can't remember. I remember talking to Yoko, getting my stuff, leaving, going to the pharmacy, and going home. But she doesn't remember the time frame that she was decapitating Johnathan. Why? She's told this has got to be eating you up. And this is why videos are so important. This is her response.
This has got to be eating you up. This has got to be eating you up.
She's nodding.
This has got to be eating you up.
This is eating her up.
This has got to be eating you up.
Ladies and gentlemen, she admitted to the murder. She said in her interview, when she confessed, that she took that object, the stick, the wooden stick, and bashed Johnathan in the head. That is the murder. But there was a head missing, and that was important to the detectives to give closure to the family. So what about the decapitation?
Well, it's, you have to have something for the hour before minutes where you were in the house. That's it. But that's the only time you don't remember.
I didn't know I was there that long.
It doesn't matter if you don't.
Because that's what I'm saying, I don't remember being there that long, I didn't know I left.
Okay, so is it possible you did it, you don't remember?
Yes, sir, it is very possible.
Okay.
Yes, sir. It's very possible. The scene does not lie. Defendant can lie, but the scene can't. So what's the hard evidence as well, in addition to her statements that are inconsistent, other than the confession? As we know, John was found on this bed, and there was blanketing. And we also noticed that there were 2 blood spots specifically on that sheet that he was wrapped in. One on one side and one on the other, as you can see in that right-hand photo. She rolled him to the edge of the bed to complete the decapitation after she had realized she murdered him by hitting him, as evidenced by the 2 blood spots that we see there. In that last interview as well, there was a drawing, there was a diagram, there was a sort of a back and forth a little bit with the defense talking about that the detective was the one drawing, but I will leave it up to you to sort of see how that was going down. Devyn drew that line there, and the detective told her multiple times, correct me if I'm wrong, is this where you were, where the X is? Yes, that's where I was. She drew him in the exact position she left him in. There's some truth. The DNA can't lie. We heard that Johnathan's cell phone was found at Devyn's house during that search warrant of the Porcupine Ring residence. And we heard from CSA Nicole Merriam, who testified twice, that she swabbed that blood spot right there on the phone, and the testing revealed presumptive positive for blood. It also revealed Johnathan's blood. It's also important to note that Johnathan's blood was found in the driveway of the residence. We have that marker A, which you can see there, the blood spots with the cone. And we also have marker B, which was that Johnathan's bed frame, where they saw those droplets of blood. All Johnathan's blood. It also is interesting where these blood spots are, because they're in the driveway in the same exact place Devyn would have walked to go back to her vehicle to drive home, as we know occurred at 2:04 in the morning. Devyn's DNA is on that knot of the plastic bag containing the wallet and John's only car keys. They also tested inside and outside of the wallet, including all the pocket openings. So the inside of the wallet also contained Devyn's DNA. This wasn't Johnathan dropping it in a bag. Why would Devyn's DNA be inside the wallet? Devyn and John's DNA are on his social security card swab. Not shocking that Johnathan's DNA is on his social security swab, or social security card, I should say. But remember, this is Devyn's bag. You see her wearing it in the surveillance video with the chevron. She also described it to police during one of her interviews. And what's found inside is that social security card belonging to Johnathan Willette. And not only is it found, but it's found with the defendant's DNA on it. She handled it. She wanted to enroll the girls at school and knew that she needed documentation because the father of the children was dead. We also heard from the coroner, Dr. Doggy. The cause of death, homicidal violence. The manner of death, homicide. The internal exam, and this is important, decapitation occurred post-mortem. Johnathan was decapitated by the defendant after she bashed him with the stick and killed him, based on the science. No one's disputing that, not even Dr. Sims today. This is also important. No bleeding injuries on John's hands were found. None. She did discuss slippage, which she explained what that was, where, after death, the skin tends to shed a bit in different areas. But again, no bleeding injuries on John's hands. Then we had testimony from Dr. Burns, who passed around those cool exhibits. Casts, I should say. And she explained that there were 2 implements used to decapitate the victim. As you can see in the picture there, this is her annotated version showing that there were 2 implements that were in fact used. A hand-powered serrated or non-serrated knife was the first. Then a mechanically powered saw, because it's very difficult to cut through human bone. Not only did Dr. Yagi and Dr. Sims agree today, but also Dr. Burns told you that the impacts that she saw on the neck were consistent with post-mortem dismemberment. Johnathan's head was decapitated after he was murdered. There's a lot of discussion during trial about whether it's possible for a woman to do this. I think it's important to note, as Dr. Burns highlighted, a mechanical saw is made for anyone. Women can do anything, especially ones that have a clear motive. Moving on to the burla. Where was Devyn's vehicle during all of this? Her Nissan Armada shows she's at Paladura during the time of the murder. We have at 11:05 p.m., there's that short activation that we saw on the burla, which I'll go ahead and play for you. And it is not very long. It's at 11:05 p.m. on that August 6th, 2023, which is corroborated by the video surveillance where we see her vehicle moving up right in front of the driveway of Paladura, nose to nose with Johnathan. Then we have 2:04 a.m. This is when Devyn's Nissan Armada leaves. And we saw that in the burla. She goes from the Paladura address, she goes to CVS, then she returns home to the Porcupine Rim address. I won't play this all for you, you'll have this back at evidence. You've seen it during the trial. We also have that call detail record mapping. Where was everyone's phones during all of this? More importantly, where was Devyn's phone during this? And we had Detective Good testify that the defendant's phone was at the murder scene when the murder was occurring. And what's also interesting to note, which you kind of have to get close to see, but there's sort of this blue dot that is now traveling with Devyn's red device all the way back. And this was at 2:04 in the morning. So that's how we know that the victim's phone was taken by Devyn back to her home, because we have that Google geofence highlighted by that blue dot there of Johnathan's phone, showing when it actually got to Porcupine Rim, and that's when Devyn got it. We also heard phone content evidence, which demonstrates Devyn's intent in this case. I worry as much as you probably won't believe. I miss us. I'm glad you appreciate what we once had. We will have it all again, Johnathan says. I want our family back. We got to do as great as we can for the girls to have a good life. The walls were closing in. We have the video surveillance that was played for you in depth during trial. And there's some important notes from that. We saw how much video surveillance was canvassed in that Paladura neighborhood. There was a point where the detective even said he couldn't pinpoint the address that I needed him to because of all these contacts here. Then we have that next door residence to the murder house, that 2696 Paladura Drive. Again, next door. And this is that video I talked about earlier where we do see the Nissan activated and we see it move in front of the driveway of the murder home, 2698 Paladura. We also see in this vantage point of the video when Devyn and the victim returned home from that trip from Chevron. When they were coming from Porcupine Rim, stopped at the Chevron, got some items, then came back, and we actually saw those shadows of two figures, which would be Devyn and Johnathan, getting out of his truck to go inside of the Paladura residence. This camera gives us that as well. And again, 11:05 p.m., we get that activation, and we see that the Nissan Armada is moved up closer to the residence. Why would she want to move it closer to the residence? She's concealing her crime. Then at 2:04 a.m., we also get from this residence that the Nissan Armada leaves, putting sort of a bookend on the timing of the murder. We then have the video surveillance from the Chevron. We've also called it the Terrible Herbs. And in there, I talked a little bit about this. We have that they're there at 10:10. That's Johnathan's truck pulled by a trailer. They then leave at 10:11 p.m. And we know that Yoko, as well as the video surveillance from the Palo Verde neighborhood, they're arriving into that neighborhood around 10:12 p.m., all corroborating, giving us our time frame. We have the video from the CVS pharmacy, the drive-through, 2:28 a.m. on August 7th of 2023. This is after the murder, where she's at CVS. Again, giving us a time frame. There's no one in that vehicle but Devyn. You can see with your eyes. We then have the 6621 Gray Juniper surveillance video camera.
Congrats,
from
Lightning.
Devyn's neighborhood. This is that one that was fixed where you could see the only entrance and exit of the Porcupine Rim neighborhood, and it was constantly running. We were able to see different things from that. Remember, it was 3 minutes slow to real time, but accurate. At 8:57 p.m., we have John's truck entering the neighborhood. And this is on August 6th. Then at 9:29 p.m., John's truck leaving the neighborhood, further corroborating the timeline. Then importantly, at 2:39 a.m. on August 7th, after the murder, we see Devyn's Armada and Devyn returning back to her residence. At no point was Devyn or Devier's work truck or that sedan seen entering or exiting. Very important. We don't see his work truck or any of his vehicles leaving until 7:31 a.m. on August 7th. So now let's talk about Devyn's motive and intent, which is very important to consider. We heard from individuals that knew about the child custody case during this trial. And they told you that Johnathan had been given full primary physical custody of the two girls, Tamea and Jamea. And this happened on October 27th of 2022. So at the time of the murder, Johnathan technically still had full physical custody of the girls. He had something he could hold over Devyn's head. The walls were closing in on her. We also heard from Elizabeth Lemons Woods, who also had worked on the child custody case and sort of the placement of the girls after Devyn was arrested. She meets with Devyn on August 17th of 2023. She wants to tell the defendant, hey, heads up, I just want to notify you the girls are being placed somewhere else because you're not there and their father is no longer around. And what Elizabeth Lemons Woods testified to is that defendant then started giving her more information, more than the scope of what the original conversation was supposed to be about. And what I think is notable is that Elizabeth says that throughout the conversation, Devyn appeared that she was trying to cry. Why would you try to cry? Devyn said during the same conversation, she had to do it. She had to do it. Now, ladies and gentlemen, it's very important, and you're in fact instructed on this, to use your everyday common sense and judgment as reasonable men and women. Do not check your life experience and what you know to be true at the door. Bring that with you when you deliberate. The evidence in this case is overwhelming.
There's an anger now, Mom.
I told you from the beginning I didn't.
So how does she feel against him?
It's hard, and Mr. Giovanni hit the nail on the head when he said, buckle up.
Oh, my ears were not happy.
This is unfathomable. But this is what happened. We are confident as the state that having all of this evidence in front of you, that you are going to go back to that jury room and you are going to check guilty of first-degree murder with the use of a deadly weapon, because the defendant committed first-degree murder under both theories: premeditation, deliberation, and also felony murder. Thank you.
Okay. Sorry, I missed part of that. My mom and brother came back, so.
Technology for the defense's closing argument. We're going to take a brief recess. During this recess, you must not discuss or communicate with anyone, including fellow jurors, in any way regarding this case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media. You must not read, watch, listen to news, or read accounts or commentary about the case. You must not do any research, such as consulting dictionaries, using the internet, or using reference materials. You must not make any investigation, test, the theory of the case, recreate any aspect of the case, or any other way investigate or write about the case on your own. You must inform or trust any meeting regarding the case or time spent to you. Ladies and gentlemen, it's 2 o'clock. We'll be in recess till 2:15.
All right, to the jury.
In recess till 2:15. Well, what did you all think of closing arguments there? Unfortunately, I missed quite a bit because Mama Llama and Bro Llama came back, so I had to talk with them a little bit before she headed back home. I'll say I was surprised to see it was the female prosecutor, because we hadn't heard much from her. She did cross some people, but listen, from what I did see, I am impressed with her not needing any notes to do it, feeling very confident. I think she did very well in that regards. I don't know if the whole overwhelming evidence I would necessarily agree with, and there's certain things that I'm like, I don't know about that, but very interesting. So we shall see how the defense will do. And it looks like, based on the younger defense attorney guy, he was taking notes, counter notes. So my guess is he's the one that's doing closing arguments. She only spent 55 minutes maybe on a closing argument there. So that's pretty, I'm not surprised about that, I guess. Also, she mentioned, did I miss yesterday when I was gone for a while for the parent-teacher conference? Did I miss some testimony then of the CPS people they were talking about? The custody and family services. She had mentioned it, and I was like, wait a second. I don't recall any of that. Did that happen yesterday while I was gone or something? Because I definitely don't recall any of that testimony. So Angie said she definitely showed that she was inconsistent and lied, but don't know if it still proved first-degree murder. Yeah, I mean, listen, Devyn was definitely lying her ass off. There's a lot of lies all the way around there. What do you guys think? I thought it was interesting. I don't know if she should have went about it this way, but they had the, count. We got, let me pull it up because I specifically took a screenshot of it. Let me download that real quick so I can pull it up here, of the charges. Well, of the murder charge, because I guess she has 2 charges, I guess. Oh, okay. So 2 testified, but they didn't really say much. Okay. I was like, I mean, I know I've zoned out a few times, but I feel like I would have at least remembered that. All right, let me pull up these charges real quick for you. I'll take you down, add you there. Okay, so these are the counts for murder with the use of a deadly weapon, right? And at the end, she has them all crossed off, except for the very first one. And I don't know if that's necessarily the approach you necessarily want to take, because you do want a verdict of some sort. But I'd be worried that the jury would be like, well, listen, she said it couldn't be second-degree murder. And she said it couldn't be voluntary manslaughter. And I don't agree that it's first-degree murder. So therefore, we can't do any of the other ones because the state said that's not the case, right? So I don't know. I could see that being problematic for the jurors of showing it that way. Like, I get what she's trying to do, but I don't know. Because I do feel like first degree is a hard one to get to, but we'll see. Holly McKibase said, did the defense put on any witnesses? Yes, they did. They put on 2. They put on a data guy who had talked about basically the investigation into devices, digital forensic evidence that they didn't download as much as they should have or looked into. That was kind of his purpose, was reinforcing that the investigation really wasn't a complete investigation. And then they had ME, who is also a forensic pathologist, who was basically there to kind of discredit the ME that did this case, which his 2 things that he brought was that it should have been undecided cause of death, undecided manner of death, right? Because the head's missing. So that was really what he brought to the table, which we already had problems with the medical examiner anyway. And her work, and was it maybe one of you guys remember, was it the medical examiner or the forensic anthropologist? I don't know which one it was, but I think it was the ME who said that this was their first decapitation case that they've worked on. I feel like it was the ME, but I'm not super confident it was her, because that was from a few days ago. But you guys, our poll is very interesting. Let's see. So for the question was, what do you think the jury's verdict will be? 47% of people said guilty, 41% say not guilty, and 12% say hung jury, which is, I think that's very fair numbers for around the board. And that makes me wonder, what is the jury going to come back with? I really don't know. Okay, Ange, you think it was her, the ME too, that was like, this is my first ever decapitation, which is, I mean, I guess that makes sense, but also weird. Because had she been like an ME for like 2 years or something like that? She's pretty new, but she had quite a few autopsies under her belt. I don't want to make her sound like she is like, has no experience whatsoever. I think she says she did roughly at least 600 autopsies, I want to say, ballpark there. So it's not that she's like completely inept or anything like that. They keep, like 600 autopsies, a fair amount. But again, she said the victim had no tattoos, and he has the biggest fucking forearm tattoo possible. Like, it's the whole arm. So there's some problems there with that. I don't know. There's just, like I said, either Devyn did it, Debbie did it, or they both did it. But there's some issues. I know they stress a lot. Like, well, it wasn't Devier. He is solid, No. All right. We all watched the testimony. Okay. It was hot garbage. So we'll see. We'll see. But I think with the poll, with it all being split up, that also shows that this case wasn't a slam dunk case, if you will. Like, clearly, because of a meh investigation, it's causing people to be like, I don't know what's gonna happen, so we'll see. Right, Pam says, I can't get over that. How would she miss? Exactly, like a whole forearm tattoo. Right, or her assistant cleaning. I would have seen. I mean, I'm just saying, it's very problematic. It's very, very problematic. So, and then when they ended with the clip of her getting very angry at the investigator, we watched that whole thing yesterday. She did not get angry at all until the very end. And both Terry and I were like, we would have lost our shit an hour ago on these people. Like, so, and then they wanted you to really end with like, look at how unhinged she is. And it's like, yeah, she probably had something to do with this, but she actually stayed fairly meek and quiet through. I mean, we couldn't even hear most of what she said. That's how quiet and meek she was when giving these interrogations and interviews. And then, like, she gets loud one time. And that's why they always say, be careful what you say, because everything you say can and will be used against you. And not in ways that you're going to be happy about. And that's a very good example of that. So, Lainey said, I missed it. Did Devyn testify? No, she did not. Nope. We just had those two witnesses I just talked about, and then the defense rested. So she didn't. I mean, is it probably a good thing? Probably. Maybe. I don't know. We'll see. It could go either way, in my opinion. So I think maybe the defense has gotten wind that a lot of people are very confused about this case, because it's not just us. Who was it earlier in chat? I don't remember who it was that said that, Vinny Politan from Politan? Whatever. Vinny, we all know who Vinny is. Sorry, Vinny, I'm getting your name wrong right now. But we all know who you are from Long Crime. They were talking about it the other day, and they're just as perplexed as we are about things. Like, it's not a strong case. But again, I will give credit where credit is due. I do feel like the prosecutor who did closing arguments, she did do a great job. Even if you don't agree with some of her points, she did do their opening and closing has so far much better than the trial in between. We'll put it that way. But she did very well. I know for me, I can't imagine if I was doing this, I would need notes too. Maybe, I don't know. But whenever an attorney can get up there and just make it seem without notes that they know exactly what they're talking about, to me, that goes a long way. If I was a juror, I'd be like, oh, this person knows this case in and out. They're very confident in what they're trying to sell me. Because sometimes when they're looking at notes, you're like, do you even know what's going on? Because you know a lot more than I do. And I can just talk about this for 2 hours, but okay. There were closing arguments too. Yeah, we just wrapped up the state's closing argument. Their closing argument was about an hour long, 50 minutes to an hour, something like that. And they're on break for another 4 minutes. And then it'll be the defense's closing argument. And then it'll go to the jury. And the jury will have probably 2 to 3 hours to deliberate before the end of the day. And I don't know if they're going to come to a conclusion then. But we will be on verdict watch here very soon. I know that damn sound check, but hey, babes, congratulations on selling out your show. I'm glad everyone in your band is good to go, especially the guy that had to go to the hospital yesterday. So I'm glad that all worked out for you. Now tonight, you guys, don't forget, a bunch of you are now members because everybody's been gifting memberships all week, which is so great. If you weren't gifted one, make sure you check and see if your your gift settings are turned on. You go that by clicking join. You'll see 3 little dots on your upper right. It'll say gift membership settings, and click on that. And then there should be a little toggle to turn that on. But for those of you that just became members, make sure you check out the members portion of our channel. Go under membership. You'll see all the videos that apply to whichever level you are. But tonight at 9 p.m. Eastern is TMI, Too Much Internet. It's our fun show. All we do is have a lot of fun and talk about silly stuff we found on the internet. Nothing serious, because we have to do that at least once a week around here to keep our sanity. And then Monday night at 8 p.m. Eastern is our monthly member appreciation stream. So any level of member, make sure you show up, because we do giveaways for all different levels. Some you have to be in the chat to win. We'll have some announcements, maybe some sneak peeks, I'm not sure. But definitely mark your calendars for that. It'll be Monday, 8 p.m. Eastern, 7 p.m. Central. So, and then you guys, if you're a huge Stranger Things fans, then you know that the new season's about to premiere on the 26th. And we in the Courtyard, our Discord server, have started a marathon watching it. We're about, we're into season 2, episode 5, I think. And we'll be finishing season 2 in there on Sunday at noon. And then the following weekend, Saturday and Sunday, we'll be doing season 3 and season 4, because we're also a bunch of TV nerds. So it's a fun time. We all hang out, kind of do what we do on here, just chatting in the side about it. We all have fun pictures. But yeah, feel free to join our Discord server. We do true crime stuff as well, but that's just where like everybody hangs out when we're not live. Or that's where Savage likes to put and tag me in reference photos of what he's talking about. So yeah, be sure to join us over there. It's a good time. And I know during the Thanksgiving break, since we're not going to be doing any live shows on the channel, we've been talking about doing some events, maybe some game nights, some documentaries. We're going to entertain people over there during the Thanksgiving holidays. So come hang out with us over there. I think that'd be fun. Oh, where's that, guys?
All right, for the jury.
Well, yeah, he does. So yeah, be sure to join us over there. It's a fun time. Come hang out in the Upside Down. Oh, I'm so excited about Stranger Things, you guys. I literally sat on my hands to not watch it at all until we reconvene again. I mean, I've seen it like 8 times, but still. I love it.
Please be seated. Your Honor, the jury is all present and accounted for.
We are going to go back on the record and see 377-239 State Nevada versus Devyn Michaels. Wait, the record reflects that Ms. Michaels is present with her attorneys.
No, sir.
Deputy District Attorneys on behalf of the state. We both parties speaking in the presence of our jury.
Yes, sir.
Yes, Your Honor.
Okay, Mr. Trustee, can you prepare for your closing argument?
Yes, Your Honor, thank you.
Whenever you're ready.
Oh,
Thank
the
you.
younger guy's not doing it. Oh, that's interesting. Sometimes I'm wrong. It's fine.
This case is entitled the State of Nevada versus Devyn.
Oh, these people don't
Proof
really
beyond a
like it.
reasonable doubt is the highest standard in the American justice system. It shows an adoption of a belief that we took from the old common law from England, that it's better to let 10 guilty men go free than to wrongfully convict an innocent person. I would also submit to you that it shows a belief and an understanding from the founding fathers that very few people have the resources, the opportunity, or the ability to prove their innocence. You've seen that through the course of this trial. You have officers come in, collect evidence, and officers are people. I'm not going to stand before you and say this officer's a bad person. We talked about it through jury selection. But officers make mistakes. People are subject to biases, to confirmation bias, where they reach a conclusion first and then kind of work backwards. And I would submit to you that that is what happened in this case. And our founding fathers understood that. And that's why they placed the burden upon the state and the state alone to prove its case, each and every element of its case beyond a reasonable doubt. I'd like to talk a few minutes about the jury instructions. We had a few technical difficulties, but you all have the same packet. I'd like to discuss just a few of these instructions. I'm not going to tell you which boxes to check. You're smart. You paid attention, very close attention throughout the entirety of this trial. You are the sole judges of the facts. You alone will decide what will happen to Devyn Michaels. Instruction number 3 talks about murder with use of a deadly weapon, and that's what the state wants you to convict her of, first degree with use. But the pleading document is telling. Instruction 3, it states, murder with use of a deadly weapon did willfully and lawfully, feloniously, malice aforethought, kill Johnathan Willette, a human being, with use of a deadly weapon, to wit, a wooden stick and or other unknown object. By striking the said Johnathan Willette with said wooden stick and or other unknown object, and or through other unknown means. And then it lays out the mental state. It has to be deliberate, premeditated, or of all things committed during the perpetration or attempted perpetration of a robbery. The following instructions in this packet lay out, after you've assumed that Devyn has killed somebody, her mental states. Instructions 6 through 16 talk about all the different mental states required. That's after you've determined that this person did the killing. There's even a number of instructions concerning robbery. It's instructions 17 through 20. You see, in the state of Nevada, we have what's called this felony murder rule. It's a shortcut. It's maybe basically getting to the shortest distance between 2 points to convict her of first-degree murder. There are, however, other instructions that I would like to spend a little more time on. And again, you are the sole judges of facts. You will review these instructions. But unlike us, who had this case for some time, this case is new. You were introduced to this case when we all met and began talking at the beginning of last week. There is an instruction concerning expert testimony, instruction 33. Please look at that. There's a common sense instruction. And I'm going to flip to that. It's kind of telling. Both parties generally point to this idea of common sense. Again, shows the wisdom. Instruction number 34. Although you are to consider only the evidence in the case in reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testify. You may draw reasonable inferences from the evidence which you feel are justified in light of common experience, keeping in mind that such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. As I go through my comments, and trust me, I'm going to leave things out. It's inherent in the process. Please use your common sense. You've taken good notes and you've paid attention. Please review the exhibits and don't take my word or that of the state of Nevada. Reach your own conclusions. Review the evidence. There is an instruction that I think is of paramount importance in this case, and it's instruction 32. It concerns the credibility or the believability of a witness should be determined by his manner upon the stand, his relationships to the parties, his fears, motives, interests, or feelings, his opportunity to observe the matter to which he testified, the reasonableness of his statements, and the strength or weaknesses of his recollections. If you believe that a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of his testimony which is not proved by other evidence. I read this instruction to you with Devyn in mind. We started this case talking about motivations. Motivations dictate actions. Devyn is not on trial. This case is not going to be, well, did we prove our case against Devyn better than they proved their case against Devyn? Devyn is the only person that's on trial. We have gone through the evidence in good faith, and I'm going to discuss that a little bit with you today in my summation, that there is evidence to believe that Devyn committed this crime. But you don't have to believe that to acquit my client. But I would submit to you that you should take that into consideration. The ultimate determination that you will make is the sole judgment of the facts, whether the state has proven this case beyond a reasonable doubt. Through the course of this case, and as you know, when we talked about it, we wouldn't have to ask a single question, present a single line of testimony. State fails to prove their case, she's entitled to a verdict of not guilty. But as this evidence has unfolded, I would urge you to see that perhaps the detectives in this case, the Henderson Police Department, were basically trying to choose the shortest distance between 2 points. Hey, we knew, and we all know, and we're not making issue that she was with him on the night in question. It's easy to reach a judgment like they did. She's guilty. But you, as jurors, must consider all of the evidence. Because unlike when you read in the paper, so-and-so's caught, and you think, yeah, he's guilty, she's guilty, you determine whether a person is guilty, not the police and not the state of Nevada. I would urge you to read the reasonable doubt instruction. A defendant is presumed innocent until the contrary is proved. This presumption places upon the state the burden of proving beyond a reasonable doubt every element of the crime charged, and that the defendant is the person who committed the offense. And again, this is why we have addressed what the evidence reasonably shows concerning Devyn. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life. And what more weighty affair of life do you have than to sit on this jury on this type of charge? If the minds of the jurors, after the entire comparison and consideration of all the evidence,
Like 10 minutes
are in
later.
such a condition that they say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, she is entitled to a verdict of not guilty. Since this is a charge of murder, I'd like to begin my comments, and I won't be long. We've been here a long time, but this is important. Let's begin at the autopsy. We had Dr. Sims. He was the lead coroner here in Clark County for 19 and a half years. You heard his testimony. It wasn't much of a cross because he didn't say much to be disagreed with. We did, however, hear from Dr. Yagi. Do you recall the question that was posed to her? Would you agree with me that a decapitation is difficult to effectuate? Remember her answer? I don't know, I've never done one. We heard from Dr. Sims that yes, it would be difficult. It takes a lot. It's involved. Dr. Yagi missed the tattoos. It was in the report. We had Oriental John. That kind of goes to the weight that you should give her testimony and the thoroughness of her examination of the body. The state's relying upon Dr. Yagi's statement, her testimony that there was no injury on the hand. You got to consider the source. Dr. Sims testified that the cause of death cannot be determined without evidence of injury, and he was talking about standard practices. Obviously, these are very suspicious circumstances. In fact, if John was murdered, it's very reasonable to assume, common sense would dictate, that the person that killed him decapitated him. And through the course of this evidence, they have not shown a scintilla of evidence that she was involved with the decapitation. She didn't do it. Determination of homicidal violence cannot be used when in large part that fatty liver or drugs and alcohol are present. He was talking basically about industry standards, what experts in this field collectively agreed upon. And we saw a variation in this case from Dr. Yagi. In this case, we did have a combination of all three. You heard the testimony about 20 times the level of THC, alcohol in the body. 0.02 was the alcohol in the blood, but Dr. Sims testified that that in conjunction with this high level of THC would cause a person to be intoxicated. That's important in this case because you will hear testimony concerning her concern, Devyn's concern about not letting him drive. As you recall, we went through all those texts beginning back in 2018 concerning Yoko's concern. And again, I don't want to speak ill of the dead, and it was no showing of disrespect towards her, but it was an ongoing concern that she had. She didn't want her son driving drunk, and that concern was shared by Devyn. She had his key. She took the key to the house. That's not evidence that she committed a murder. This is extremely important, and there's been a great deal of issue made concerning this video evidence. As you recall, through the course of Devier's testimony, I read it to you at the beginning of the trial and read it to him, where basically we had a detective, it was the 12th of September, telling him, you're under the radar. We're here to clear you. I mean, when you look at the radar, when you look at this net that was cast, it has so many holes in it. The state would have you believe that both homes were under 24-hour surveillance. It's just not true. The evidence of Detective Lippisch and the other detectives showed that. The state expects you to accept representations made by Detective Lippisch regarding the true time of the videos from this residence. And I want to start there. This concerns the state's timeline, which I would tell you flies in the face of common sense. But it's important to take into account how this evidence was gathered. You recall the list of times or the videos that were shown? He supposedly didn't, it was on a neighbor's cell phone. We saw no logs. We saw no indication of the veracity or the accuracy of those times. The state's basing this idea that she's pulling up in front of the Talavera residence and is somehow moving her car at 11:04 to avoid detection. You have to take this detective at his word. And again, I'm not necessarily saying he's lying, but he did a sloppy job of collecting that evidence. And this is the video evidence that I'm referring to. Remember, there was no embedded data here. We don't have time. He would have you believe that the vehicle is moved at 11:04. We don't know what time this is occurring. We do know that the vehicle perhaps was moved from the Burla, but we don't know the sequence of events. As you recall, and you will have the evidence, there was various blue lines showing triangles, and we heard that through the positioning of the GPS, you have movement, even if a vehicle is in one place. We don't have specific times, and we really don't know the order of how things occurred. We would urge you to believe and to consider that common sense would dictate that this was when Devyn left the residence at 204. There's going to be a close-up here. You'll have a computer screen. Zoom in on it. Here you see the interior of the vehicle. You see Devyn getting in. You see a bag on the passenger seat. And she leaves. Please pay close attention. And again, not that I'm trying to tell you to do, but we've had this case for much longer time than you have. Look at the video evidence from 6505 Taylor Creek. Detective Lippers testified several times that he could only speak to items that he can restore, but he was happy to testify concerning other detectives who went unnamed that collected this evidence. It's clear from the testimony of a forensic examiner O'Brien, whose credentials and whose testimony went unchallenged that we presented to you today. He testified that one of the 3 videos was compiled from a series of screenshots, which the Ring camera is set to capture by default in the absence of video activity. Where are the other screenshots? They only gave us 3.
I don't know whose dogs those are, but they're not mine. I don't hear any.
I'm not going to stand here and point the finger and say that this was done in bad faith. It was done out of sloppiness. Why weren't subpoenas issued? Why don't we get the complete record? This woman is on trial for murder. We heard nothing concerning them going to the third-party providers, Ring, Google, other parties. No, they're relying upon the cooperation of neighbors who are living their own lives and who very well may be indifferent to the gravity of this situation. Didn't give us the full picture. And that was the video that had constant, I mean, you got a good scene into or a good view of the residence. It's incomplete. We just have these 3. And again, this is at the new residence where it's been referred to. Porcupine here, we've got the truck. You know, there's been an argument made that Devyn had to have been in the home the whole time. Based on what? Because the entrance to the neighborhood with the continuous camera doesn't show a vehicle. There's other ways to leave that residence. There's a walkway next to one house away. There's over the fence. This is something that's been discarded by the state, but again, I would submit to you that it goes to what Devyn is thinking. It goes to her innocence. She starts trying to contact Johnathan on the morning of the 7th, starting about 4 a.m. She'd left him. She'd left him at the residence. The plan was that they were going to take the girls to school that morning, and we have evidence, and you've heard uncontradicted evidence that that's what she did. The message she leaves him is concerning the girls' school supplies. She's letting him know that their daughter was sick, because we know that she's at that pharmacy, and it's a 24-hour pharmacy at 2:28 a.m. That's what went on. She hadn't killed him and decapitated him. She was worried about getting her daughters to school that morning. She sends messages of concern when he doesn't respond. The state claims, and again, this is where common sense comes into question. The state claims that Devyn was answering Johnathan's phone from the house the morning of 8/7/2023. You heard the argument concerning the notifications. We did hear from Detective Skinner that they didn't put it on airplane mode. those notifications wouldn't have shown up, that evidence, like so many other pieces of evidence, were mishandled. The state's going to have you believe that she purposely took the phone from Paladera to Porcupine Rim and leave it out on the driveway, and at the same time be calling it and answering it and leaving it on the driveway. That flies in the face of common sense. She took it and left it there, and then is answering it and calling it to provide some sort of an alibi. She's lucky that in this very slipshod investigation that she has as much evidence that she does to present to you that she didn't commit this crime. Crime scene, the footprints. There are footprints in the backyard. And we have, and I'll show you the photos, we marked them and had them admitted. We have this, the Henderson Police Department documenting these footprints, but then trying to basically throw shade on that, saying, well, they could have been there for some time. They weren't important. The yellow, when you look at the photo, you can see that they're fresh. They wanted to argue that are male or female. They didn't do any follow-up. There was no footprint comparisons to anybody's shoes in this case, much less Debbie Ayers. You recall Yoko's testimony, there were 4 dogs in the backyard. If that footprint had been there for very long, common sense would dictate that the dogs would have walked through it. They would have been sullied. They weren't. They were fresh. Again, they were not analyzed or tested. There it is. And Detective Ozawa just kind of discounted that and said, well, we don't know how long they were there, but apparently no one really looked at Yoko's testimony and Yoko's statements. 4 dogs were out there for most of the night.
It looks like a footprint on the moon.
This was a big point of contention. And again, these aren't red herrings. These go right to the very heart of the case. There was no blood cast off in the bedroom. In spite of evidence, uncontroverted evidence, the mechanical powered saw was being used to decapitate Johnathan. You recall, Coroner Yagi went so far as to try and compare a beheading by a mechanical tool there at a crime scene.
Maybe.
And Dr. Sims took issue with this.
I hope so.
She tried to compare that. These crime scene analysts tried to compare that to the dismemberment of a body under controlled conditions by specialized tools in the morgue, bodies that have been refrigerated. But nonetheless, she testified that they still wear protective goggles and aprons to protect themselves from this cast-off. Luminol, we heard no testimony whatsoever that luminol was used by the crime scene analysts. That would show indications of blood or attempts to wipe it up. Nothing. What's clear, and it was kind of laborious at the beginning of this trial, was Yoko's testimony, because her testimony was so crucial to the timing of this case. There were some difficulties with the interpreter. However, I'd submit to you, she speaks pretty good English.
A lot of problems with the interpreter.
To memorialize what she told officers the morning of in the 40-minute conversation, as well as what she testified to the grand jury. She testified that she saw Devyn at 1 a.m. and Devyn didn't have any blood on her. If you follow the state's timeline, it's sometime around then, and it's unclear, she's involved in this murder and decapitation. She stated that no gloves were worn by Devyn when she met her at 1 a.m. And you recall the testimony concerning the dishes and the alcohol bottles. And there were some issues concerning Jonathan's level of drinking. 15 minutes. She testified that the light was on. That brings to question the veracity and the reliability of the statements through her multiple interviews that Devyn made to the detectives. There was no blood visible on Devyn's shirt at the CVS drive-thru.
Hold on, Elba, I'll call you.
God that she stopped there. Because again, we have real time. We have real evidence that shows that she didn't commit this crime and not some detective's opinion. There's another issue concerning this, the mixture of ammonia, bleach, the stench. Remember that? We heard that the first responders, that they said that the smell got worse the longer they were there. If we're to believe the state's timeline, this is smoking for 9 hours. That flies in the face of common sense. Ammonia evaporates quickly. And again, your common experiences. The state never, and one of you posed a question to Dr. Sims. Again, it's the state and the state alone that bears this burden. Where was the expert to talk about that? That was important. This case was out of the ordinary. It's clearly gruesome, but because it's gruesome doesn't make that woman guilty. It isn't evidence that she committed this crime. Here we are, 2:27 in the 24-hour pharmacy, and you'll have this. Look at her. She's sipping her water. Apparently this is after she's murdered a man and decapitated him. She's reaching out of the vehicle. No marks, no blood, nothing. And Sims testified that this would have been messy. So she's just decapitated. She's murdered and decapitated Johnathan. She's making sure that she picks up her daughter's medications on her way home. Was there any stops? There wasn't. There were no, her vehicle didn't go to any isolated areas, to any trash bins. There's been times when I've gone through moves and I've gone behind the bonds and dumped trash out in their dumpsters. There's no evidence of that because it didn't happen. The state will have you believe that there's this bucket of blood that's the reciprocal of all this blood that's squirting out when she's sawing his head off. What did she do with that? If she did, the car didn't go anywhere. She went home. There's no rags. There's nothing in that vehicle. We do know that they recovered, and this is based in part of the video that we saw from the terrible herbs. Again, I don't want to point fingers, but her life is on the line. They didn't do their job. There was no direction of what to get and when to get it. We heard from Detective Lippish that he got that video evidencing her clothes around the 11th of August. That warrant was served on the 7th. We didn't hear much about what they picked up on the 15th. They made a big deal about the shoes, the swoosh, but we showed you evidence in the photographs, and it's in evidence of the black shoes with the white soles. I mean, she gets arrested on the 15th. Game over. It's done. According to Yoko, and this is important, and I read the statement to her because it was so dispositive. She said Johnathan's room was a mess. And there's this kind of a feigning of not understanding. And I said, man, these are your own words. And I read her own words to her. During her initial interview, she stated that there were 2 chairs flipped upside down. That's evidence of a struggle. But then we don't see that on the body cam. What happened? We don't have that in any diagrams of the crime scene. But when she spoke to police, and thank goodness it was recorded, she talked about 2 chairs being flipped upside down. And obviously her memory would have been far better at that time.
Of course, I came back to the chairs.
But again, that there were some questions by the state. You were traumatized, things were terrible. I'm sure it was. But the veracity of the statements and the accuracy of the statements shine through. She was trying to help law enforcement and give them clues concerning who committed this murder. There's no reference made in Devyn's statements about chairs, about a struggle.
There we go.
Johnathan was killed after she left. It's kind of weird is that there were two belts tied together on the ground near the bed. There's been no explanation.
You know where to
by
find
the
it.
state, and we can't give you one, but something's going on in here. Crime scene GPS. Devyn's car is trackable. We know that she didn't stop. You know, she was there that night, and that's why she was charged. Her phone is trackable clearly. No deviation is made to some remote location. She went to the pharmacy and went home. There's no anomalous stops, and this was brought up by you. She gets the medication and gets home because her girls have school early the next morning. The timing, and this is obviously where timing is very, very important. We do know when they leave the terrible herbs. You see 22:11. We know that when they got home, they spoke to Yoko. We don't know how long they spoke, but do you recall Yoko's testimony? Her words were, it was a very good day. She'd known for months that they were getting together. They were trying to unite the family. You know what? No union is perfect. Hey, we all know that. There are ups and downs, but she and Johnathan had a union. You know, the state in their first closing, they're going to get a second one, try and paint her as this devious, manipulative, conniving temptress. But think about that. The flip side, a 19-year-old. You know, when we talk about motive, what drives a person to murder, is it not passion of a young man? His first love that's coming to an end when dad's coming in and moving him, the dad that he said was never there for him. You know, it's kind of an archetype, you know, the father that's killed by his son. I mean, it's in, I believe it's Isaiah 38:18.
I say, tale as old as time.
Greek stories of it, Oedipus. I mean, there's various variations of that, but it's an archetype. Saturn. It's known, and it's as old as the human condition. Fathers are sometimes killed by their sons, and that's why we wanted to underscore, and we spent a great deal of time in our opening statement because we didn't know where it was going to go with Devyn, but we knew that they'd had a relationship that had been kept clandestine. Devyn covered for Devyn, and Devyn covered for Devyn. This is important. I would submit to you that this is a more accurate and a more reasonable timeline. Yoko was awake. 10:58. There's a 44-second call to Devyn from her phone. You recall, we get the text, and you want to talk about an alibi type text, putting the girls to sleep. It's 10:36. I'm going to bed. That has been refuted by facts. He testified here that, well, maybe he woke up at 2. That was the first time. Previously, he had testified before a grand jury that he got home, put the girls to bed, went to sleep, woke up, Devyn was there. That is a lie. Why would he lie? What motivation would he have to lie? He's a fairly smart young man. I mean, he was kind of catatonic here, and understandably so in the witness chair. But again, we need to look at motivations, because motivations, they author actions. At any rate, and we knew the night before that Devyn had been there late with Johnathan. But after we were to believe that he's asleep at 10:36, we've got a 44-second call from Devyn's phone to Devyn. 8 minutes pass. 11:05, we get that 10-second burla in the Nissan Armada. It may have been moved. You're to determine that, because I'll tell you, we really don't know. The evidence is not reliable. Whether it pulled up and stopped or what we saw there was Devyn leading, we don't know. States to provide that to you, the timeline. They haven't done that due to this slipping through the cracks in the slipshod investigative work. Now, an hour and 55 minutes pass. Yoko is awake. There's no suspicious noises or activities. And we have a 15-minute timeline. Because you recall, Yoko's into time. She corrected me. She looks at the clock. They talked for 15 minutes. And it was kind of like pulling teeth. She admitted about the dishes and the alcohol. They talked for 15 minutes. We're to believe that, and again, this goes to Devyn's statement and the reliability after she's subjected to interview after interview. Yoko says the lights are on. The state would have you believe, apparently, that Jonathan's dead. She struck him in the head and he's dead. Meanwhile, she has this 15-minute communication.
It's a no-win.
Again, no blood, gloves, chemical smell, any of that on Devyn. At 1:15, Yoko goes back upstairs. And you recall yesterday, that was kind of rebutted Lana's testimony. They kept hitting her with that hour and 4 minutes. That's why you don't talk to the police. That's why you have a right to remain silent. One thing that we have learned is don't talk to the cops, especially if you're the target.
Facts.
Because they're going to take what you say and they're going to twist it.
They can and will.
Yoko
Use it against
was equivocal in her testimony when she testified before us. This time, and she's just testified once before a grand jury, she's equivocal. She was awake the whole time. She looked at YouTube. She went to sleep. It's equivocal. But at 2 a.m., for the first time here, she says she hears the bang. And I think we had the prosecutor bang his hand. She never talked about that before. But still, may have happened. 2:04, Devyn's leaving. Maybe it was the door closing. We don't know. That's her testimony. But you have to evaluate her testimony. But again, this is really kind of shedding light on this timeline. She previously testified that she heard dogs at 3 a.m. She brought it up 3 times during her police interview. Apparently, she felt it was noteworthy, and she testified to that September 14th before the grand jury. Yeah, the dogs are barking. It's 3 a.m. Someone's put the dogs outside. The facts, taken as a whole, and not this little piece here and this little piece there, show that this murder, and it's silly to say a murder didn't occur. Obviously, it did. It happened after Devyn left. The facts, taken as a whole, bear that out. Again, you heard, and it's uncontroverted. Devyn leaves at 2:04. What's of note is that presumably Yoko went to sleep after she went upstairs. Part of her testimony previously is that she was awake during this whole time. Where's the testimony of a mechanically powered saw? It happened. It's more reasonable to believe that that happened after 3 a.m. We don't know when it happened. She didn't do it. The dogs were outside barking. Somebody's in that house. Somebody has killed Johnathan and somebody is cutting his head off. Again, what kind of passion does that take? Not an on-again, off-again relationship that Devyn had with him. It's a person that's enraged, Well, watch the TV, the police stories. They talk about stabbings are personal versus a shooting. What's it going to take to cut a head off? And what kind of anger and what kind of resentment is that going to cause for someone to do that? There's been a great deal of argument made and points attempted to be scored that Devyn did that because she'd do anything to get her kids. It was uncontroverted that regardless what was going on with family workers, she had those girls from May 27th on. She had them all summer. And when we talk about motivations, we know that Johnathan was moving in. There was talk of marriage. And, you know, they want you to believe that the rings weren't there. Look at this investigation. Look at the photographs of the trash cans. I believe one was Exhibit 68. We have no evidence and nothing to show that they emptied that. And no, why would they take a picture or preserve a ring? They didn't preserve anything else in those trash cans. It's easy for them to come in years later and say, I didn't see a ring. There was no notations, and they go through hundreds of crime scenes. When they were there, you know, when Miss Wilson was there, they were looking for weapons. They were looking for evidence of a murder. They weren't looking for rings, and they're asking you to convict her on this shoddy police work and have you believe that Devyn's lying about these rings when there is no indication that they were looking for rings. This is the state's only evidence that she committed this murder and this decapitation, because you got to put them together. Common sense would dictate whoever did one did the other. The interviews of Devyn Michaels. I'm going to focus on the third interview.
And then, have you guys ever had a sexual relationship?
Yeah, we had.
Okay. But it's not there now?
No, I can't really have sex now.
This is important. This isn't something that Devyn is making up. You have her medical records. The time, 12/5/22, vaginal hysterectomy. She's had surgery. She's not having sex. She's telling the detectives the truth.
Right, that was in December 5th of 2022. This happened August 7th of
Is there any
23.
reason why Jocelyn or anything DNA related would be in your vehicle? Because that, up to the back to our station, our CSA, they're gonna thoroughly look for everything in that vehicle.
I couldn't tell you. If he was bleeding from when he was doing the thing, he helped load up the truck. So if he was bleeding,
It was or your on it.
my Armada, like, he was putting the things in the car, like anything else
Sure,
he had.
there's gonna be obvious areas where blood doesn't belong even if you're loading. So I'm just asking you directly, because if we do find any DNA evidence in that vehicle, obviously we wanna make sure we asked you if there would be a reason.
No, the only thing I knew he said was his hand that he hit on the table. That's the only time he ever said he was bleeding, and he said it got a pretty good gash.
That you didn't see of.
No, I did not, so I can't really speak on it. But he was still loading everything up, so I don't think it was really bothering him that much.
This is the inside of the Armada. With the testimony from Ozawa, it appeared the vehicle had just been washed. That's been disproven. The burla shows that that didn't happen. The location coordinates show that that didn't happen. Look at the inside of this vehicle. I know my partner, Mr. Horvath, had asked Detective Spangler, well, you know, was it very clean inside? I think he made a reference to teenage kids, something along those lines. This isn't well kept. I've seen much worse, but it's not well kept. The important point is we're to believe that there's buckets of blood in here. There's bloody rags. There's a head, a murder weapon, a saw. There's nothing in there. They sealed this vehicle and they took it off. If you're to believe that she murdered and decapitated Johnathan, you're to believe, common sense would dictate that there's going to be some indicia of a crime in here. You're taking buckets of blood because they weren't at that residence. This made reference, and again, nobody understood the significance at the time. You know, Miss Miriam didn't. There's the table that she talked about. It was a moving day. Injuries do happen. You know, we're to believe, again, Dr. Yagi's, the reliability of her testimony. She said there was no bleeding injury. Well, we've got an injury right there. Whether it's bleeding or not, we don't know. But that's sign of an injury. And remember, this is the same doctor, the same coroner that said John didn't have tattoos on his arms. Big point was made about the telephone. And we're to believe that Devyn is so sophisticated and so cool and so cunning and so informed that she can murder this guy, decapitate him, not leave any evidence, and then drop his phone in the driveway. You know, a more reasonable explanation, it's tired. She's got girls that are going to school in the morning. She's been carrying things, it's late. She obviously brought the phone, whether it was knowing or not, we don't know. It appeared that it had fallen on the side. She tries to give an explanation. You recall about the cigarette butts? She didn't know the phone was there. That's why she was calling the phone, following up with Johnathan. She knew he wasn't dead because she didn't kill him. Another thing, there was a big point of contention. Sometimes little things can have very large implications. Remember the issue about the blood on the screen? Papakostas, the DNA expert, testified that she couldn't confirm that it was blood. There was a presumptive test, but the confirmatory test, and some of you are far more knowledgeable than I am, it was not, she couldn't confirm that it was blood. So then the state recalls crime scene analyst Miriam to apparently discredit their DNA expert in reference to the blood. And this is the entity that's charged with proving this case beyond a reasonable doubt. They're calling a crime scene analyst on a presumptive test to discredit the DNA expert who gave testimony, uncontroverted testimony, concerning the lack of a confirmation for this blood. We know that John's DNA is on the phone. I would submit that it is somewhat significant in determining whether the state's proven this case. Devyn's isn't. It was handled.
I don't think so
Maybe
either,
there weren't
Puff.
epithelial cells left from Devyn. Clearly, Devyn took the phone, knowing or not, and I would submit to you that given the circumstances and the chaos of a move, she didn't know she had the phone. It's not evidence that she killed him. Just like the key, it's not evidence that she killed him, or the wallet. She's going to go through all this work to leave this, this crime scene spotless or clean and not leave anything behind, no blood, nothing in her car. That she's going to drop the phone and then make calls to it. This is what the state is relying upon, this interview. And you recall the tenor of this interview? Please don't just look at one part or another. Listen to the whole thing. The power dynamic. You've got two large men. You've got a woman who they had said, we Mirandized you earlier today. I have to ask yourself what went on. What happened before this interview?
John? This is Johnathan in that song?
Yeah, but he had his boxers on.
Okay, he had his boxers on.
I don't know, he had his boxers on. His boxers were black boxer briefs. He had boxer briefs on.
That's what I'm talking about, the shit's getting real. Keep looking at that. Take another look at this.
This was into the interview, and it was a fairly lengthy interview. She'd had multiple interviews before. We heard in this interview that they had told her previously that day about the decapitation. So there's more going on. She knew. It's at 1601, and it's interesting that the state showed you the exhibit, the one that she supposedly wrote. When you look at the original exhibit, it says handwritten by Devyn Michaels. It wasn't. She drew a line, and that's significant. It was Detective Christopher that wrote that. And again, this is in the crises, in the crucible of a very confrontational interview. She didn't author that. And I'm assuming that Mr. Giordani is going to stand up when I sit down because he gets the last word. He's going to say that somehow, how could she have known that? She hadn't been shown the photos. This gentleman had seen the photos and he filled in those details. And she's sitting there having been arrested previous to this interview and facing the horror of being accused of a crime, a murder that she didn't commit. Here's the boxers. Why lie? Why lie? When she left, he was wearing those boxer shorts. She was consistent in that. Why choose that hill to die on? She was telling the truth.
Have you had moments in the past where you have been stuff where
Yes,
is that
there's things in my past where I cannot remember. And yes, I have talked to my doctor about it. Yes, they're trying to figure out what's going on with me. Yes.
okay? You don't have to tell me if you don't want to, but what is wrong with you that you say that
I
you're trying
don't
to get
know,
back?
they're testing me now. I think yesterday, for whatever reason, my brain tingled and I blacked out. And I literally have it on documentation from the doctor, and they're trying to figure out what's going on with me.
This interview was on August 15th of 2023. This condition that she's talking about, it's documented 6/7/2023. Your patient established her patient she feels like tingling, vibrating in the back of the head, comes and goes, denies headache, has dizziness. This isn't some ploy. I mean, she's in this high pressure, confrontational interview, and she's trying to give as truthful information as possible. She's had some problems. This isn't some defense where, oh, she blacked out and didn't know what she did. She didn't commit this crime. She didn't commit this decapitation. She's had some issues that she's been trying to address. And again, she's being truthful to these detectives.
You're fired, Angie. Effective immediately. Just kidding. Just kidding.
Absolutely. And earlier that you can't even have the audacity to give in closure. Shame on you. That's terrible. Get out of here! Kill me up there! Also, there's some anger now, huh? I told you from the beginning I didn't do it. How do you feel against him? No! It's not how I could have too.
She's pushing back. She's been interviewed over and over again. She's telling him, I've told you I haven't done this. What we're dealing with now is a woman that's denying that she committed this murder. You know, it'll be up for you to determine whether she hit him in the head when he was grabbing her leg. She was consistent that he was alive. He was breathing. There's no evidence that she hit him in the head. And again, given this, we know that when people are confronted, they'll try and give something to appease the other party, this power dynamic. She was trying to give. In this interview, you'll read, they threaten. What you do here is going to determine what happens with you and your daughters. She gives a little, but then snaps back and says, I didn't do this. And she's expecting, through all these interviews, for them to pick this up and do their job. But they'd already made their minds up. You heard from Lanai yesterday. In their minds, she was guilty. That's it. And we're dealing with this investigation that you heard from Sean O'Brien, 3%. We're dealing with 3% of the information that was available on those devices. But still, in that 3%, we've been piecing together what really happened. We do know, and it's clear, incomplete Celebrite reader files. Critical database files are missing from the phones. Now, years later, we're trying to piece together a defense to defend a woman that didn't commit this murder. There's artifacts which would indicate a need for further investigation. And Sean O'Brien testified that generally, as he's been a forensic analyst, he's been involved in law enforcement. There's supposed to be this back and forth. Hey, get us this. You know, as this investigation develops, we need more information. There was no indication that that occurred in this case. She's at the house. She's the low-hanging fruit. She's guilty. The end. All investigation stopped. Image of Devyn and Devier. And again, we would like to have more, but we can show you this image. Now, all the images that are available on a cell phone, I think I probably have 4,000. You know, it's going to be the state's position. Well, this is just randomly popping up. Devyn had said that he was asleep, or Devier had said that he was asleep at this time. He testified under oath. He lied under oath. Look, there's a Discord chat application, 231. This is telling. You know, the state can play 3 phone calls from the girls who are adorable. Those were all after 11 o'clock. We have no proof where Devier is. But we have 2 indications of 2 artifacts at 2:12 a.m. and 2:31 a.m. that he's up and he is engaged. There's a deliberately deleted file. This is the image, 2:12:38 a.m. This is after there's been 3 calls from the home phone that night to Devyn. 3 of them were the girls. What about the other 8? But of all images, 2:12:38 a.m., this is being looked at on Devier's phone. Game box. Again, and this is important, this was not preserved, this was overlooked. There's photos. He was a gamer. They had issues. Gamers are on their game platforms and they talk to other people. We have a Discord file. There's a remnant of that. He's using that at 2:31 a.m. in the morning. He's up. He didn't drive his car over there. And again, I can't tell you for certain if he committed this murder. But he could have easily gotten out of the house, and he's not going to walk. He's going to talk to a fellow gamer. We now know that he's up and he's lied. He's lied under oath. What does he have to lose? I mean, he was able to avoid the motives through the course of this investigation concerning getting kicked out of his house and losing his wife, who he, based upon all the photos, and we didn't have to go through those, you saw them, he was in love with her. But we do, in this 3% that's available to us, we can show you that he was up. Not 1 indication, but 2. And given the nature of that photograph, the multiple phone calls that were made earlier, and now we have this Discord, we have a remnant that he's on an app. It's not too hard to imagine that he went there. Those are the facts. And the timelines, you recall the detectives that for the Henderson Police Department that testified, they set out timelines, but they didn't do a more in-depth analysis. And this is what our analysis was only 3%. We were able to show he was awake. This was deleted. It's there. I'm not saying that was that night, but that's something that should be taken into account. Headed there now. He's there in this area, and you'll have the exhibit. He's next to a remote area. Don't know if he had a job there or not. This is the morning after 8/7/10/25. You know, when detectives interviewed him, he'd said, hey, I've been drinking. We don't know if he'd been drinking all night. We don't. He's a drinker. He's in a remote area where, and obviously there's been no testimony, there's been no investigation in those wash areas. We know he was over there. We know he was up. We know that he was looking at a picture of him and Devyn. You know, it's, you see on the crime TV shows about motive, means, and opportunity. He had all three. He had the motive. He had the means. He didn't walk there. But he
I
was talking
very
to
much
somebody.
think he had a motive.
Clearly, he had the opportunity given the timeline. But again, I'm not going to stand before you and say he did it. We don't know. She didn't. These were texts that were between him and his father. You have nothing to tell me, WTH or TF. I thought you were my seed. If what I can know, I can't fuck with you, or that's true. Devil shit. It was clear, and he tried to smooth things over through the course of his testimony, but Devyn did not like his dad. He had an affair with his dad's girlfriend. You know, these things don't reflect too good on her, okay? They reflect poorly on Devyn. But Devyn's not here for good moral character. You can despise the choices that she made, but you can't convict her for murder, for a murder that she didn't commit. This is their home. The home that he's being kicked out of. Again, there's the walkway down the side. There's the way to get out the back. There's no cameras that were pulled on Rebecca. We don't know. The police did a slipshod investigation. We can't show you him walking away. They didn't collect the evidence, but the motive would point to Devyn. This gun, there was an issue made concerning that. That gun was looked at the afternoon of, I'm sorry, that's another gun.
Hey, Sam.
There's guns in his possession. We don't know if that person was shot or not. Johnathan was. The swords, again, we're not trying to throw these things out, but this just shows a conscious indifference on the part of law enforcement in collecting evidence that could exculpate her. Their minds were made up. She was guilty. There's so much evidence here that you can go through and look. Again, thank you for your patience. Thank you for your attentiveness. You know, this is the last chance that we'll have to speak. There's going to be things that I have overlooked.
Don't forget, the state's got a rebuttal, guys.
Don't hold them against her. Hold it against me. You remember the movie 12 Angry Men? The jury went through and exonerated that young man. I'm going to ask you to do that, to look at the facts. You may not be comfortable with a verdict of not guilty. She's done some bad things.
We should watch 12 Angry Men in the Discord.
She didn't kill him and cut his head off, because those two things are combined. Common sense would dictate that they are. She's not guilty of this charge. Thank you.
All right, Chuck.
Are you prepared to give your rebuttal argument?
Did not end on a Tolstoy banger, but what can you do?
Ladies and gentlemen, because the state has the burden of proof, they are allowed to open and close the closing argument.
Let's talk about reality.
3 hours.
I want to commend my colleagues over here who represented Ms. Michaels first, because they've done an exceptional job. And Ms. Michaels is entitled to a fair trial, like we talked about.
They are so nice to each other.
They've done a good job of coming through and poking as many holes as they can in the evidence, and I commend them on that. But make absolutely no mistake. That woman is guilty as sin. That family deserves justice. Those girls deserve justice. Do not take this lightly just because a real polished defense attorney gets up here and spins a yarn for you. Do not take this lightly. Those people deserve justice. If I were to tell you that a defendant confessed to a crime, described how she did it, everything she said matches the crime scene, except for the part where she minimizes or potentially blacks out the aftermath, you would say, well, that's pretty damn obvious. And some of you were probably sitting there when we played that confession the other day, yesterday maybe it was, or the day before, and go, why didn't you guys play this 2 weeks ago? We could have kind of sped this process up. Maybe you're thinking that. because we have to show you that the cops did their job and she is overwhelmingly guilty. We wouldn't be doing justice to that family right there if we just played that confession and walked. And we didn't. We put 2 weeks worth of evidence up here to show you Devyn sure didn't do it and she did. There is no reasonable doubt in this case whatsoever. And I want to address kind of an elephant in the room. You know, Mr. Draskovich just got up here at the very end and he told you those two things, you know, common sense dictates those two things go together. And I kind of agree with that, right? The person who killed him probably decapitated. But make no mistake, she's not on trial for decapitation. She's on trial for murder. She told you she did the murder. Now, she minimized it. She told the detectives that she hit him over the head and he was still breathing. Of course she did. But she admitted to the act that caused his death. Are we really, as reasonable men and women, going to believe this was a fatty liver or a marijuana overdose? Are you kidding me?
Literally nobody said that, sir.
That guy was murdered and then his head was chopped off. And here's the elephant in the room.
I'm pretty sure that guy didn't say
I don't care if you for some reason believe Devyn somehow snuck out of his home like a ninja, crossed town, and cleaned up the job. I don't care. She's not charged with decapitation. Look at the pleading document. She's charged with killing John. That is it. That is your job. Did she kill him or not? And the answer is absolutely yes. I need to show you a couple instructions because they're important. Bear with me. I know you're probably tired because we all are. But this is too important to just gloss over.
Hey, Mama
This is a
made it
beyond
home.
reasonable doubt instruction. Mr. Draskovich addressed it.
Good.
I want to tie this into another instruction. Doubt to be reasonable must be actual, not mere possibility or speculation. Instruction 31, direct versus circumstantial evidence. The top part is really important. I'm going to address that in a minute, but this one down here that's underlined is also important. You must not speculate to be true any insinuations suggested by a question asked the witness. So a question is not evidence and may be considered only as it supplies meaning to the answer. So everything Mr. Draskovich said through the course of this trial was a question, right? It was a question. That ain't evidence. So you tell me what piece of evidence, what single piece of evidence suggests Devyn did this? Not one. Not a one. And when you start accusing an innocent guy of murder, Devyn, you got to think about this for a second. That young man was taken advantage of. And like Miss Griffith said, it's not like he wasn't enjoying it and liking it and into it. No doubt. Mr. Draskovich in his opening statements suggested that Miss Michaels has a history in the adult film industry. Did you ever hear me ask that? No. Did you ever hear me or her mention that? No. Because Mr. Draskovich is right. She's not on trial for having a past. Doesn't matter.
You're having a past.
The only
What was the
reason
other
that
word?
does matter is because it dictates that relationship with Devyn a little bit. It colors it. She is an experienced woman, much older than Devyn. He's a young knucklehead, and I would submit to you that when you heard from him, no disrespect, but that guy's not a criminal mastermind. He's not somebody who snuck out the back of the house, evaded all cameras, left his phone behind because he was thinking ahead to what he was going to do, somehow made it all the way across town, even though he didn't have his phone to contact anyone. There's no Uber notifications or pickups or anything suggested. There's no calls, no text, nothing after 11 o'clock. So who did he contact and when? There's no evidence that Devyn was involved in this. None. There's actually evidence to clearly refute it. You heard those voicemails, and we can agree those little girls they're precious, they're adorable. Those voicemails eliminate this alternative suspect, which I will refer to as a scapegoat, because that's what's happening to him. He's being scapegoated, and it's not right. Those little girls said on those voicemails what Devyn was doing. He was knocked out, probably passed out, to be if we're being honest. And you didn't hear any other voicemails afterwards. You saw more calls from the landline. If Devyn had got up and snuck out, because we know the one little girl is awake and panicking and like scared and where's mommy? She should have been home a long time ago. Where's mommy? Wouldn't there be another voicemail where they're calling going, Devyn left us? Like, really, Mom, where are you?
Not if you never went to the room.
Of course there would be. And there isn't. That's because Devyn was home. And you know that because he texted and he said, I'm going to sleep. He's no criminal mastermind. His phone is at home. There's no evidence his vehicle's left. There is zero evidence that Devyn is involved in any way. Zero. And so Mr. Draskovich brought up a good point with the instruction that Ms. Michaels is the only one on trial. That's instruction number 36. I want you to think about this for a second before you let a guilty person walk. Okay, think about this. Imagine if I were to stand in front of a bunch of jurors and try to prove Devyn's guilt. Imagine that. That's not what we're doing here. That's not what this is about, but imagine that for a second. Can you think of a single piece of evidence I could, with a straight face, present to a jury and say Devyn did this?
His testimony was shit, sir.
Speculation and really good questions by a really polished.
He lied about numerous things.
There is not a piece of evidence. I would be laughed out of the courtroom if I tried to prosecute Devyn for this homicide, because he didn't do it. He had no reason to do it. Go look at the text messages between him and his dad. We included a bunch of them. Did he worship the guy? No. Did he hate him? Who cares? He didn't kill him. There's no evidence to suggest it. He says throughout the text messages to his dad, hey, what's up? You'll see it. There's like years of it. There's 2 years of it. And then those texts that Mr. Draskovich just showed you with the devil shit, I would submit that's a reasonable thing when you learn that your son is having sex with your ex or is married to her. That's reasonable. But then, they left out a text that's right after that, where dad is reaching out to Devyn like months later saying, hey, this wasn't some big rift, homicidal relationship between dad and son.
He shouldn't have done this.
When you're thinking about motive like that, you've got to think about this defendant. She told you in that interview with Detective Llama and Christopher why she did it. She said it clear as day. I didn't think he was really going to move in. The walls were closing in on her, and she made a real horrible decision. A real bad decision. She said that she very specifically got up. He was down on the bed getting a massage. Got up because she was a little pissed off, I think were her words. Maybe don't quote me on that. Something like that. Walked across the room, grabbed this heavy blunt object, bashed him over the head, and he went limp. That's a confession to homicide. Okay. On top of that, she told a DFS worker, when you're thinking about motive, in the context of losing her children and homicide specifically, which she brought up, she said she had to do it. She had to do it because that's how she felt. And I'm going to answer or try to answer a couple of unanswered questions for you. We all get this evidence before trial. We're all obviously somewhat prepared. I'm not like tooting our horns, but we're prepared. We know the evidence.
I kind of want to FOIA this case because I need all those.
There were clearly going to be unanswered questions in this case, right? There's a missing head. There's a missing murder weapon. There's missing implements, no doubt. But think big picture, forest from the trees. Think about reality, right? Criminals ditch murder weapons all the time. Criminals try to cover up what they've done all the time. Just because she ditched the head and therefore the doctors can't confidently say what injury did it, Does that mean she gets a reward? Like, does she get to benefit from the actions she took to cover up? Of course not. Does that mean we can't convict her of murder? Of course not. And that is why I asked the Dr. Sims those questions earlier. I didn't challenge his credentials. Like I've dealt with him on cases before, as you probably noticed, and he's a smart enough guy. He's very educated, but he's not disputing that a blunt blow could kill a man, right? He is saying exactly what Dr. Yagi said, the decapitation is post-mortem. And you know what he didn't say, which should be very notable for you, that there were other bleeding injuries on the body, including the hand, right? Because there weren't. He didn't say that because there weren't any bleeding injuries to the body except for up here. And that's how we know she did it. That droplet of blood, you can go back and forth about the DNA analyst not confirming it's blood. Well, DNA analysts actually look at DNA profiles. And DNA is in every single cell of your body, including your blood. And so, no, a DNA analyst is not going to come in here and say, John's blood was on the phone. She's going to say, John's DNA was on the phone because she's a DNA analyst. That's what that is. John's droplet of blood being on that phone convicts the defendant even without her confession. Set those, two confessions actually, because she told the DFS worker she had to do it. But set those aside for a minute. There are no bleeding injuries on his body except for up here. The phone left at 2:04 with a droplet of blood on it. That means the murder happened before 2:04. It had to. Nothing else would make sense. Nothing else would make sense. She, the defendant, traveled with that phone. Okay. So then you got this other big glaring unanswered question. How could someone be capable of doing that? That question, I can't answer. Okay. This is reality. It happened. I would submit to you that there is a chance that what she said about that hour and 4 minutes is true. Maybe our psychology major could talk about this. But I would submit to you that she may have been genuinely telling those detectives the truth, that she didn't remember chopping John's head off. Because this is beyond anyone's wildest dreams. Violent beyond all imagination. And there is a good chance she blocked it out. That doesn't mean that she walks out the door because she says she can't remember. It convicts her. There is no way she didn't do this. The evidence is absolutely overwhelming. And I need to address a few points because I just can't leave them unsaid, so please bear with me. Mr. Draskovich called into question Devier's testimony, and I want to bring this back for a minute. I think Devier is pretty well excluded. He walked into this courtroom, and I want you to remember that I asked him the question, did we bring you back? We didn't have to arrest you or anything. He came back willingly. He flew here, right? He brought his girlfriend, a little more age appropriate now. I guess he's learned his lesson, but walked in the courtroom willingly with that big old camera and all you strange faces to him. And he sat on this witness stand. He swore an oath to tell the truth.
Okay, buddy.
He got up here. He testified. He looked at his wife. He looked at all of you. He looked at me. He looked at the marshal with the gun and the badge. And he testified to the best of his ability. Now, I am not and will not endorse his character. I don't know the guy. I've met him a couple of times because he's a witness.
I know he's bad.
You got to see him tell you the most intimate details of his life. And I asked him straight up for a reason, and I did this early in the trial because we just learned he's the defense. Put him up early, and I asked him, did you kill your dad? And he said no. Now, I know he's a stranger
So
to
obviously,
you,
it's fine.
and you can't just accept his word, but you've got to consider the circumstances and what it took for him to do that, to put himself in front of the world, and testify about all this. Willingly. He came back. We flew him back from California, and he came in here and
You
he
flew him
answered
back.
questions from a very skilled defense attorney for however long he was on the stand. Think back to that. Did that kid strike you as someone who snuck out of his home, plotted this big old thing, and killed his dad and then somehow covered it up? Or did he strike you as someone who got himself in a bad spot, his words, tried to fill some shoes he had no business filling, and made a series of mistakes in relationships? That his testimony from the stand has to be considered in context. And it's all corroborated. Now, I would submit to you that if he came up here and he said every word consistent, precise with everything he said over the last 2 years, then you might rightfully be a little suspicious. Like, oh, what is he studying for this? He had some inconsistencies. We don't shy away from that. He's not perfect.
Some.
Yeah, I asked him a question. I think the word I used was tumultuous, and he's like, what does that mean, sir? I don't know what that means.
That was not a
He's
problem
not a
with his
criminal
testimony.
mastermind. No disrespect to Devy, but he's not a criminal mastermind. He's a scapegoat. Don't let that happen. Need to address our pleading document. Mr. Draskovich brought this up, so I just have to address it. So
Sorry, guys.
you heard in the beyond a reasonable doubt instruction, it says the state must prove every element of the offense beyond a reasonable doubt. This is a legal pleading in Nevada. We are permitted to use unknown means and manner of death and unknown deadly weapon. This goes back to what I was saying earlier and what Ms. Griffith said about the deadly weapon instruction, where it says the state is not required to recover the deadly weapon used and present it in trial. There's a reason for that, because like I said earlier, this happens all the time. We don't reward criminals who are smart enough to get rid of the weapon. In addition, we don't reward criminals who are smart enough to get rid of the head after they crush it. That's why we are legally permitted to do this. Unknown object, unknown cause. Only question is it murder? Is it not? Did she do it? That's it. And it's absolutely first-degree murder. Mr. Draskovich brought up the robbery instruction, or the robbery pleading felony murder stuff. So I need to address that as well. Instruction 18. So when you first heard the charge read by the clerk, I'm sure you're like, what do you mean by robbery? This doesn't really, it doesn't really make sense. This doesn't really seem like a robbery, but bear with me a second. Taking property by means of force is a crime. The motive and reason behind it is separate. So yes, she took his wallet, his keys, and his social. We're not saying she took that for its value, right? It's not like the traditional robbery. The evidence says she took that for a reason, and it all comes down to one thing, and that's the girls. She took the Social Security card because she knew she had John out of the way, and she was going to make some changes and live the life that she wanted to live. So it is by law a robbery what she did. She killed someone, took their property, but we're not saying that she took the property to take the property. She took it because she wanted the girls and she wanted John out of her life. Instruction 29 is the motive instruction, or we call it the motive instruction. Motive is not an element of the offense or the crime charge. We're not ever required to prove motive, but you're permitted to use it to color kind of the facts of the case and determine whether there was a motive that could lead you to convicting on the crime. I've addressed motive a little bit.
Wrap it
I
up,
just want
sir.
to kind of wrap up that idea with this. John and Yoko and his side, they had a very different understanding of the moving situation than the defendant. Okay. She didn't want it to happen. Go look at the text, especially the ones that Miss Griffith showed in her closing. John is continually saying, I miss my girls. I miss my girls. I want you girls back. We need to put this family back together for the sake of the girls. And go look at the defendant's responses. Those ones that Miss Griffith showed. One was, I'm glad you appreciate what we had or how it was back then. And then that last text she put up where John is saying, we need to do this. We need to have them under the same roof. She doesn't
I didn't
respond.
either, Savage.
So go look at those when you're thinking about motive.
It's right there.
And tie it in with the last statement, the confession. There is no doubt that both sides have been aware of this potential for a move. What I would suggest to you, the evidence says, is that she didn't want John moving in, and John did. John wanted that. And it didn't become real until that night. And you know that because of the conversations with Devyn. He's still there. He's literally still living there. So if he was going to be moving out for John to move in, why isn't he moved out?
But no motive, guys.
That's because no one expected John to try to make the move that night. And that's when the wall started closing in on her. She's thinking in her head, I want my girls back. I want my girls. That's it. This guy can't move into my house. That's not what I want. She wanted him out of the way. And she did what most reasonable people wouldn't do. She made the decision to take a blunt object and bash him in the head and kill him. I want to address a few things with the defense expert. Mr. Draskovich showed a couple of cameras and a couple of texts or activity, 212 and 230. One's a Discord, one's a photograph. Remember what their own expert said. That wasn't active activity. That could have been background activity. It could have been active. He can't say that. So whether Devyn woke up and activated his phone at 212 or 230, well, that just tells you he's still at home. And if it's just background activity, then who cares? Either way, it's not good for the defendant because it rules out Devyn. It's either with his phone or it's a nothing burger. Mr. Draskovich talked about the boxer shorts being off, and I already mentioned this. The defendant may very well have blocked out what she did after she killed him. And whether she took the boxers off or not doesn't really matter. It's probably very likely that he was naked when they were having this massage situation, but the boxers being on scene have no real import in this case. Mr. Draskovich talked about the CVS pickup, and I got to address that. So he said, and he showed you the video, there's no blood on the defendant in that drive-through. Now, we all watched it together. I don't see any blood from here up from what you can see. But do not forget, that shirt was never recovered. Neither were the shoes. Now, I'm not saying,
I still think those are the shoes by the door,
to you
sir.
or suggesting that I know what the defendant was wearing when she decapitated him. She could have been naked. She could have put John's shirt on. She could have changed her clothes, a number of things. But what I am telling you is that white shirt, from here up, maybe no blood on it, but it's never recovered. So we don't know if there's actual blood on it.
Was it not recovered because you
Mr.
couldn't
Drastic
find it,
asked
or
me a
just
question
they
and I
didn't
need
see
to
it with their
provide an
eyes?
answer. He
So
said, is that a woman picking up this medication for her girls that's just done this, has the wherewithal to have just done this and go pick up medication? Yes. Yeah, that's reality. You heard the voicemails. The little girl was saying, you were going to get my medication. I'm not saying that the defendant is a bad mother. I will not say that. That ain't right. She took her children's father away. That's a bad thing she did. But did she care about her girls? Obviously. She stopped to get medication? Obviously. That doesn't exonerate her in any
hi,
possible
Mario.
way.
Welcome.
And neither does the post-homicide messages she sent to the victim's phone in the early morning hours. There is two very real explanations for those messages. Number one, you already know the extremes she went to cover up what she did to his head. She took it. That's extreme. She poured chemicals. She took a bunch of stuff from the scene, probably a towel too that was on top of him when she did the chopping. It's not outside the realm of possibility that she sent a text and made it look like she thought he was alive. That's certainly not unreasonable. The other explanation, as I've intimated to and pretty much said directly, is that she doesn't remember the real bad stuff, and legitimately in her mind,
Cheers, Mario.
he was still alive after she hit him, because from then on, she blocked it out. So take those text messages for what they are. They're either she's alibying herself or covering up, or she genuinely doesn't remember the wet work. That's what that is.
I know I need him to wrap it up because my Five Guys is waiting on me and it's getting cold, sir.
I have to mention the timing of the big confession, not the one to the DFS person, but the big confession. If this is all, there's no evidence to say this, but according to Mr. Draskovich, this is the defendant covering up for Debbie here. If that is true, why does she confess after she's arrested? Right?
It's called a read technique,
She's
sir.
already been arrested. Debbie has gotten away with it.
I'm just kidding.
Why does she confess after? Unless it's what happened.
No, Elbow Feet wants to eat
Mr.
together.
Draskovich showed a couple of videos, the small movement off screen.
He's waiting.
Remember the 2696 video? He showed the small movement off screen, and I believe he said, I'm sure it was just misspeaking, but I want to make sure it's clear, that was the 204 movement. That was not. That, according to the detective, that was the 11 p.m. movement when it goes off screen. And we know that for a fact because the burla shows that exact movement at 11, or it's 11 or 11:04, I can't remember. The 204 footage on that video is when you can't see the car, it's already out of frame, but you can see the lights turn on and it leaves. And then that is also consistent with the burla. So just needed to clarify that.
No, I'm going to eat with Elbow Feet together. So we can have dinner together for once this week. So it's fine. I'm fine, guys.
Want to briefly address the girls. So you didn't hear from them in this trial. You can probably imagine why we wouldn't want to put them through anything more than what they've been through. I would just ask you to, that's my decision. I live with that decision to not call them. But I would submit to you that you heard everything you needed to hear from the girls in those voicemails.
Nobody needs to hear anything from the
Devyn
girls,
was
sir.
home. Devyn was asleep. That's it. need to briefly address this DNA stuff. So Mr. Draskovich made a point about the swords, the shower earlier in the trial, not an argument, but no blood being in the Nissan Armada and the footprints. And I just want to take this to its logical conclusion. So say we swab the swords and any one of the three's DNA is on it. What question does that answer for you that hasn't already been answered? If Devier's DNA is on it, it's, well, he's handled the swords before. If the defendant's DNA is on the sword, it's, well, she lives in the home. Of course, her DNA is on the sword.
You had no problem with
If
everything
John's
else.
DNA is on the sword, it's, well, yeah, those are his swords and they were just moved from his house in the move, right? That doesn't answer an actual question in the case. DNA being in the shower. The defendant's been to the home many times. Have we found her DNA in the shower? What is that going to change for you? Absolutely not. No blood in the Nissan Armada. There is so much evidence of her covering up her acts at the crime scene. It should not be shocking to you that she could have wiped up some blood if there was any in the Nissan Armada. We know from the patterning at the scene, and you look at it for yourself, the blood on the ground, there is something she used to collect that head. There is a very straight, clear line on the border of that blood that suggests that something caught that head. And whatever that was, she took it with her. And when the defense says there's no stops along the way, we agree. But what they can't say, no one can say, is what she did when she got home. And you may remember that many times, different witnesses talked about it being trash day. It is
Well, those
not very
cameras,
hard to walk
ensure
over
nobody
2
walking
homes
around.
or 3 homes and dump a bag or basket or whatever it is in a trash can. And, you know, I got to address the investigation. Now,
Oh my God.
the detectives are all learning this stuff as the investigation goes along. They didn't have the burla and all that stuff when they go to Porcupine Rim on August 7th. Should they, because of they did know there was a head missing, should they have checked every trash can in the neighborhood? Yeah, probably. But they didn't. Okay. That doesn't mean that she didn't dump the head in the trash can. And that doesn't mean that this investigation gets the case thrown out or the defendant acquitted. These detectives actually did a pretty darn good job of follow-up investigation. When they suggested that she was the convenient, shortest distance between 2 lines, I disagree with that. Because remember, they found all that stuff in her home on August 7th. All that stuff, highly suspicious, blood on the phone. Did they arrest her then? No. Could they have? Yep. They didn't. They went and did mountains of follow-up investigation. All of that confirmed the suspicions. And then she confesses after she's arrested.
Remind me to talk about her getting rid of the head in the neighborhood, because I have thoughts. Oh, I didn't realize we were going to take forever.
Miss anything, so bear with me. I know it's getting late.
I know.
Almost.
It's not great, and
Instruction number 35 is important. In arriving at a verdict in this case as to whether the defendant is guilty or not, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict.
hello, Charles.
I want you to take that to heart. There's a phrase that's commonly thrown around in this courthouse. It goes, admit what you can't deny, deny what you can't admit. say it again. Admit what you can't deny, deny what you can't admit. I want you to think big picture, forest from the trees, just one more time. When there is a confession and DNA and mountains of phone evidence and video surveillance, what could the defense possibly do? She's covering up. The only thing that these very skilled defense attorneys could say in this case. We, luckily, have a mountain of evidence to disprove that. Admit what you can't deny, deny what you can't admit. They were painted into a corner. I commend them on their job, but what they did is they blamed an innocent person for a homicide he didn't commit. And I don't want you to blame the defendant, Miss Michaels. I don't want you to judge her based on whatever her past. No one's asking you to do that. I also don't want you to take into account whether she's a good person or a bad person. She seems like she has some good qualities about her. Seems like she's trying, to be a good mom. You must not make this decision based on sympathy or a popularity contest. Mr. Draskovich, very likable. We're not here to do a popularity contest.
Oh my God, wrap it up,
real
sir.
Real stuff. Okay, real.
He
stuff.
almost said real shit.
Do not think about whether you think she deserves a little leniency or redemption, or this is a one-off. She lost it. None of that matters for you. That matters for the judge, Judge Jones, who in her wisdom will sentence the defendant, not you. That is not your calculus. Your job is simple. Did the defendant do it or not? That's it. Please remember your oath to follow the law. It's my understanding the judge is going to let you stay a little bit after to deliberate tonight. I'm sure you might get instruction on that, but please don't take this lightly. This is important to more people than just the defendant. She is guilty beyond a reasonable doubt. Guilty of homicide.
Oh, Mario, sweetie.
Thank you for your time and attention.
That's the
these 2 weeks.
state.
We really appreciate it.
He's the prosecutor. Just, I don't know when you popped in, but that's the prosecutor that just
I'm now going to ask the clerk to swear in the officers to take charge of the jury and the alternate jurors.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them, nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God.
All right, ladies and gentlemen of the jury, as you know, a criminal jury is composed of 12 members, and there are 14 of you who are here. That is because 2 of you will serve as our alternate jurors. This means you are not discharged from your service as a juror. Your service may still be needed if one of the other jurors is no longer able to participate in deliberation. In this case, our alternate jurors are juror number 13, Ms. Fitzpatrick.
Oh, we just don't need any audio, apparently. That's not me, guys. That's Law and Crime for some reason. Oh, you know what? They might be saying names, and that's why we can't hear it right now. Never mind. That makes sense. So while they're determining alternates, my guess is they're using their real names. So riddle me this, okay? The state wants you to believe that we have all these ring cameras, all this footage, that there's no way that Devyn could have left that house at all, because we had cameras everywhere, right? Yet they tell you in closing statements, well, we don't know how Devyn got rid of the head, but we think she might have put it in the trash can somewhere around the neighborhood. But we don't have her leaving the house. We don't have her walking around on all these ring cameras. Why does that apply to Devyn, but it doesn't apply to Devyn?
May the record reflect we are outside the presence of our jury. Do you guys have any further matters?
Oh, I'm just saying that to me. But by the way, I just want to say, I do think both sides did a very good job in closing arguments. Definitely the beginning and the end, I think both sides did great. The trial itself, they were not super great. So I do commend them on their opening and closings for sure. All of them, I think, did a good job. What bothers me about both sides' closing arguments is, listen, we watched this whole freaking trial together, and I do have a problem when, yes, they want you to go with their side and their narrative, but it's like, okay, it wasn't really like that, and you're kind of trying to make it like that, and we all saw it. Like, and both sides did that, which bothers me a little bit, but so I guess they are going to be deliberating tonight. I don't know if they're going to reach a verdict tonight. I hope they don't. And the reason I say that is because they do have a lot of evidence to go through regardless, right? You want the jury to at least think about some things ahead of time. They have a lot of evidence to go through that we didn't even get to see. Like, I've never wanted to file a FOIA, but oh, do I want those text messages? I really do, actually. But let's see. It is 5 o'clock their time. Or no, I'm sorry. It's 4 o'clock their time. It's 7 o'clock my time. So I feel like they'll at least be allowed to deliberate for up to 2 hours based on what the judges said previously on other days. That the latest that the jury said what they would say was like 6, which is 9 o'clock Eastern, my time. So we are in jury watch. I don't know how this is going to go. Let me do your guys' poll real quick. So when we started this, we said, what do you think the jury's verdict will be? We started this part 2 stream, and 59% said guilty, 24% said not guilty, and 18% said a hung jury. And who knows how the jury's going to go, but I think that's showing a lot of how not super strong this whole case was. But we shall see. As much as I would love to sit here and hang out with you guys. All right. I got a Five Guys burger and fries waiting for me. So I will be leaving here just a minute to do that. So happy you found us as well, Shannon. And to all of our new viewers, please subscribe, hit the notification bell. We go live and do drop episodes like literally all of the time. So please make sure you do that. Oh, Sir Charles says, I was friends with Johnathan and I'm still friends with the family. A lot of things that have come out, but again, she's in my mind, in my opinion, guilty. Well, I mean, it could be. And listen, our thought, just because it's kind of hard to explain, just because some of us may feel that the state didn't do a good job, that is in no reflection. You can think somebody's guilty and yet they don't have enough evidence to convict them. My heart is especially out for the girls. Oh my gosh, those sweet little girls. Their dad is gone in a horrific way. Their mom has been in jail for 2 years. Their brother / stepdad is just basically fucked off to California. It sounds like, I don't know, but I'm just saying, I feel so much for them. They're so young to have this happen to them. And, I have a lot of questions about how the investigation went and how the case was handled in court. I do, and I understand you're friends with the family. I do think either Devyn or Javier or both of them had something to do with it based on what we saw. But you, as a family friend, you know them better than we do. So we'll have to see. We're not on the jury. But I do think they're going to take some time and think about it for sure. Which I forget which attorney, was it the defense attorney? Maybe it was both, mentioned that many of the jurors were taking notes, which is always good. They had some great juror questions as well. So listen, the jury is alert. Whatever they come back with, I do feel like it will be really thought out, so. Oh, thank you, Juju, who says, great channel. Llama and Terry are a great team, and chatters on the channel are smart, hilarious, and loving. And we're welcoming of all viewpoints. As long as you're not being like super disrespectful to somebody else, all viewpoints are welcome. We're not all going to agree all the time. So, but listen, I am going to go eat my dinner because I'm very, very hungry. I haven't really eaten today. And at 9 p.m. tonight, for our members, we have TMI, Too Much Internet. It's so much fun. I can't wait to do it because, oh my goodness, we have had a very long and busy week. We just have fun, laugh at stuff on the internet. Amos has promised me that there's going to be more mystery date VHS date videos, which are our favorite. So I look forward to that. As soon as a verdict comes in, whether it's tonight or Monday, we will be live as soon as we get the word for that. So please do make sure you have to go in to the channel where there's the little bell, the notifications, and you have to click all in order to get that notification. So I appreciate everyone being here with us today, as well as our new friends and subscribers. It was so nice to have you in chat. Monday, I don't know what our schedule, necessarily next week is. We'll see if a verdict comes in tonight. If not, we'll be around on Monday. So if I don't see y'all tonight, I hope you all have a wonderful weekend. And I look forward to seeing y'all next week. Until next time, go forth and be amazing. Bye, guys.